Well, good afternoon, everybody. Welcome back to Hearing 4. Here's Commissioner Littlejohn. I've just noticed that it's being, the recordings just come on. So again, as is our case, we'd really like to start with a karakia. If someone's available to do that, that would be good. Otherwise, Julie's always perhaps prepared. And Antoine.
Kia ora mai tātou.
Yes.
I was just looking through the list of people and I haven't quite got them all on one screen. I'm happy to do the karakia unless someone else would like to offer us to start the meeting.
Sounds like it's you, Antoine. Thank you.
Kia ora mai tātou. Whai korori hareru ki ngā mano mātua tama wairua tamarina puna me te māngai. A tātou ki te kauri ki wairua te ara pajama ki pururi tua hāmoare te tīmatanga o tika mātua tumatu nei. A ko te māngai no hei tautuku mai ai ni ākini ai. A e te māngai na poro te tokoro tapu. A kia tātou mai no koutou ko wainga nui ki tēnei whakamoemetia mātou. A hei tātaringa kupu kātua whakapua kena na mātou i rauta koutou kororeatanga ko te māngai no hei tautuku mai ai ana i ākini. Āmeni.
Thank you, Anton.
Thank you, Anton. So just, I am pretty sure just looking around the Zoom that everyone has actually been to one of our Hearing 4 introductions before. If you haven't, perhaps turn on your video and speak to me and we can just acknowledge you. Someone there? No. Okay. We'll carry on. So look, this is the final day for Hearing 4, and it's split into two items. The first item is the report back from the Section 42A team from the council. There's 5 subtopics, and we'll hear back from each of those reporting officers, and perhaps also from Mr. Lloyd. I'm not sure on that, but we'll hear about that. The second part of the topic, the final part of the hearing, is a discussion organised with the council planning team and the panel just about some of the matters associated with how the plan frames matters of discretion and a few other questions we have for them, which we'll make a decision about after that, how we proceed and whether we might need to issue some interim guidance, but we do want to have that discussion. So that's set for 3 o'clock. And Antoine, I know we've asked both you and David to come on board for that second session. You're most welcome to stay and listen to the first part as well. Particularly given that I think you do have a role with some of the provisions around Methanex, so the noise one in particular. So it's
yes, that's correct.
Yep. Yeah. So I think it'd be good if you could, if you do have time, we can stay on and listen, and that would be great. Thank you. So Sarah, are we handing over to you just to introduce things from here?
Sure. Good afternoon, commissioners and submitters and any members of the public that are on today. Today we're going to hear the right of replies from the reporting planners on issues that were raised during the hearing. The chapters and the order which they will be covered are: we're starting with temporary activities, and that was with the reporting planner Dermot Friendly. Moving on to light, so you will hear from Erica Jane and Hamish Wesney. The third item will be noise, where we'll hear from Holly Gardner, Hamish Wesney, and with supporting acoustic expertise from Nigel Lloyd at that time. The fourth topic will be signs, and you will hear from Ellie Gibson on that. And finally, finishing up with Earthworks, where we will hear from Nicola Lawrenson. You may note that there are some other planners that have joined the session today. I have asked Joe Ritchie and Jacob Stenner from the District Plan team along to help answer any questions that the hearing panel may have in relation to resource consent processing to do with oil and gas activities, and the Waihitonga and archaeological sites review, and how this work has fed into the proposed district plan. Their presence today is simply to provide context, and if you have questions, you are most welcome to ask questions of them, but if you have nothing to say, they obviously can just observe. Any questions that relate to the evidence heard still does sit with the reporting planner, so just to understand that distinction there. There were 6, at the end of Monday afternoon session, there were 6 matters that you raised with me. 4 of the matters I was able to provide a response to you at that time, meaning today, when we get to the second part of today's meeting, I will focus on those 2 matters, which I understand to be the process for a pre-hearing meeting with federated farmers, and then the second point being the approach taken and how we have approached matters of discretion for the proposed plan here in New Plymouth. So you will probably, so you'll come back to me at the end of that, but of course I'm here if you do have any questions that do pop up during the right of reply.
Thank you, Sarah. And I think because Commissioner McMahon, David has got some other matters he's dealing with, he won't be with us until 3 o'clock. So if we finish, any chance we'll finish early for the main part of the report back, we'll just take a break and then reconvene at 3 o'clock. That's okay?
Sure.
Thank you. Right, so Dermot.
Kia ora. Everything working well in terms of audio-visual capabilities?
Yes, you're loud and clear and very clear there, Dermot. Thank you.
Alrighty. Well, kia ora koutou katoa. Tēnā rawa atu koutou. I'm Dermot Friendly, and I'm a policy advisor in the district plan team for the New Plymouth District Council. I considered the submissions on and wrote the Section 42A report for the temporary activities chapter. Overall, I do not think that there was extensive discussion really around the temporary activities chapter from the submitters, so I'll try and keep this concise. I'd like to start with Commissioner Littlejohn's broader question from day 1 of the hearing in how the strategic objectives fit into the chapters themselves. The strategic objectives do not directly mention temporary activities or feed into the temporary activities objectives and policies directly, but I don't think they necessarily need to. It is worth noting that UFD 13 does relate to enabling social and cultural vitality, which is definitely applicable to temporary activities, and there's the connection there. Based upon listening to the submitters over the course of the hearing, I still consider that the only area of real contention for the temporary activities chapter is around Rule Temp R2 relating to temporary military training activities. I do agree with Ms. Baverstock's assessment that in most instances, temporary military training activities would not need consent. That's from, I can't remember which day it was, but that was from the Defence Force there. Most of the discussion around temporary military training activities was focused on the noise rules themselves rather than Temp R2. So I'll leave that discussion for the noise verbal and written right of a reply. I do note that there was no discussion really around compliance with Sign R3 and Light R1 rules, which are matters of compliance for Temp R2. I still maintain the same opinion as in my 42A report that neither Sign R3 nor Light R1 are onerous to comply with, and they should remain as part of Temp R2's assessment. I do not think that Temp R2 and Temp R3 would need to be set out separately from one another if there were changes to be made to the noise rules, as Noise R4 relates only to emission of noise from a temporary emergency management training activity. if it were to be considered that sign R3 and light R1 are not relevant to temporary military training activities, then I would suggest separating them for the sake of clarity. Overall, I consider that the temporary activities chapter is fit for purpose and will achieve sustainable management outcomes for the New Plymouth District. Are there any matters that you'd like me to clarify further, or anything that you'd like me to go into detail for my written right of reply?
Dermot, for me, I think that has been very clear. I agree with you that there's quite a limited range of matters in your particular subtopic are at large. And just one question, have you moved any of your recommendations based on the Defence Force submissions? You may have, or have you stuck pretty much with what you've recommended in your 42A report?
Probably the most notable part of the submission that I did take on board was that we didn't actually, it was lacking in terms of an objective and relevant policy for temporary military training activities, that they weren't specifically mentioned in either the objectives or the policies. And because the definition of temporary activities explicitly excludes temporary military training activities, it was kind of left out. And so we've put that into an objective and a policy. So that it does have a policy and objective sort of relevant to temporary military training activities.
So that'll show up in Appendix 1 of your written
Yes.
right of reply.
Yeah.
All right. So just perhaps
But
for you.
that was in my 42A report.
Oh, that was in your
Yep.
42A report.
Yeah,
So that was already there.
Yes,
Okay.
yeah.
But nothing further after hearing the evidence.
No. I mean, I do consider that, most of the discussion was centered on noise R7, R8 and R9 really. So it was kind of not so much on temp R2 itself.
No, I remember that. So that's good. So no further questions from me. Thank you, Dermot, and thank you for your participation and assistance. I hear this might be your first
Yes.
hearing, is that right?
Yes, it is. Yes, coming live from my kitchen.
So well done and good experience, I think.
Yes.
You've sat through some of the other, or have you sat through the other matters on hearing 4 as well?
Most of them, yes. Yeah.
Yes.
Yeah.
All right.
No,
So,
it's been a good experience. It's been interesting.
Yes.
Kind of funny doing it through Zoom, but I've got nothing else to compare it to. So
yeah. All right. Well, will we see you again in other chapters, Dermot, or?
yes, I'm doing the open space zone, which is coming. Open space in sport and recreation zones.
Yeah.
Which is coming up soon. Yeah.
Okay. Well, hopefully we can see you face to face.
Yes.
In the same room with that one. So thank you.
You might not recognise me.
Yeah. Oh, that's good. Commissioner Littlejohn, do you have any other questions?
No, thank you for that. Looking at Ms. Baverstock's attachment where she's included the track changes, I can't see that she's identified any red to the 42A report recommendations. So, I mean, I'm taking it from that NZDF are happy with your recommendations around temp R3. And I don't think she even mentioned the amendment you made to the objective and policy to incorporate them up the front because it's not included. So we take it from that there's no real issues in contention between the submitters in respect of these provisions. So that's helpful. Thank you.
Awesome. Thank you very much.
Thank you, Dermot. So is it Emma Jane there?
Yes, I'm here, thank you.
Light.
Yes, kia ora koutou everyone. I'll be doing the officer's verbal reply for the light topic today. For conciseness, I will focus this right reply on the main issues that were raised during the hearing, but I'm of course happy to take any questions on any other matters you may have. So the main issue that we discussed on Monday was with the Director General of Conservation, which is mitigating the effects of artificial light on Indigenous fauna. So the submitters sought that the Convention on Migratory Species, Light Pollution Guidelines, Wildlife, I'll refer to hereon as the guidelines, be included as a permitted activity standard in the light chapter. The submitter points out that this requirement would be more consistent with the NZCPS and the Taranaki Regional Policy Statement. To summarise the proposed standard put forward by the submitter, artificial light within 20 kilometres of identified habitat areas would need to meet the standards for light outlined in the guidelines for best practice guidance. I agree that lighting installed in line with this guidance would provide better protection for the seabirds and shorebirds of concern, and that this is a matter we should seek to address where possible. However, the proposed 20-kilometre radius from the identified habitats covers much of New Plymouth City. As outlined in my original Section 42A report, I understand the standard would apply to all outdoor lighting in the district, and I still have some concerns that it's not practically feasible. In addition, due to the subjective nature of the best practice lighting design principles covered in the guidelines, I consider reference to the guidelines in the standard put forward by the submitter lacks the specificity required to be an enforceable permitted activity standard. However, to address this and to look at potential alternative solutions, I've looked at the 2020 Southland Dark Sky Plan change and the 2021 Wairarapa Dark Sky Plan change, the Mackenzie District Dark Sky provisions, and the light controls in the Nature Preservation Zone in Hastings District. My first main finding in these is that these areas have more restricted light standards, but they are often very rural settlements with very small towns. Carlton and South Wairarapa towns being the largest covered by these, and the smaller ones being Twizel and Oban. My second main finding here is that the areas with stricter rules, the lux limits tend to vary from 3 lux at the low end to 8 lux in the Wairarapa and the Hastings Natural Protection Zone. Mackenzie District doesn't have a specific lux limit, but instead controls lighting through shielding, filtration, direction, and a mapping overlay where the stricter light rules apply. Mackenzie also has a larger emphasis on using objectives and policies to control light rather than rules and standards. Noting the above examples, if these are the lux limits in the dark sky areas, 10 lux for a city and residential areas in New Plymouth seems relatively appropriate. My third finding from reading through these examples is the supporting documents of the Wairarapa plan change in particular note that the dark sky provisions largely aim to control sky glow via methods such as light filtration, controlling the brightness of lights, and controlling the warmth of light tones and direction shielding. These measures are not necessarily geared towards controlling light spill and glare, which is what we are seeking to control, although these are controlled as a byproduct of the dark sky provisions. So the dark sky provisions may not be quite fit for purpose in limiting the effects of artificial light on seabirds and shorebirds. However, the Wairarapa and Southland dark sky provisions do provide some potentially useful wording for enforceable lighting standards that could be adapted to manage the effects of lights on seabirds and shorebirds as described by the Director General of Conservation. So looking for that solution, as the best practice lighting guidelines are not worded as enforceable standard, and as the dark sky provisions aren't necessarily created with the intention to control the type of artificial lighting that affects seabirds and shorebirds, my recommendation is that a potential solution would be to adapt and reword the best practice lighting design principles in the guidelines to create enforceable standards to sit within the district plan. The question that remains for this approach is the appropriateness of applying these standards to all areas within 20 kilometres of identified habitats, which would cover much of New Plymouth. Existing use rights would mean that the standard would only apply to new outdoor lighting, but this is still quite potentially a large number of lights and a large compliance and enforcement burden. However, existing use rights also raises the issue of how to control existing lights in the district that are having adverse effects on seabirds and shorebirds. So I note that there is potential to use Section 17 of the RMA where light is especially excessive or problematic to the environment. We'll continue to work on this potential approach and wording, and we'll present our conclusions and recommendations in our written reply. Moving on to the second main issue that we covered.
Can we just
from-
can we interrupt and just have a chat about that now? Is that okay?
Of course.
Because I mean, I'll be honest and say I think your thinking is going very much where my thinking went, in terms of you look at some of the standards that essentially say light spill must not be emitted in the angles above the horizontal, for example. Very simple, very clear. Or must be shielded from or directed away from adjacent roads and site boundaries. I mean, that's essentially what the guideline is suggesting that people do anyway. So I think it's a good idea. The issue, I think you've identified it, is where you apply it to, in a way. I think there's probably, well, do you think there's enough scope in the minister's submission to, for example, apply it only to the rural production zone or the major facilities zone? Or do you think we'd need to sort of stick with this within 20 metres of the ranges per the map that we've got as an overlay to some extent?
Yeah, I think there would be scope to apply it wherever we see fit, but I guess the question there is, why would we apply it to the rural production zone or the other zones as opposed to the whole district, when the Director General has identified that the habitats are the areas of concern? I mean, except of course that, you know, lighting within the city itself is difficult to enforce, but then I'm not sure what the evidential basis for that would be. But I can certainly look into that as a potential solution. Yeah,
and I think if you see Ms. McNichol's memorandum that she sent round, she's sort of done a little bit of thinking around that already. If you look at the way she's suggested some tweaks to standard S1, which bring in those fully shielded standard. She's put one in about the artificial lighting colour, about the 300. And there is this other suggestion, although it's included as a note in her proposition, isn't it? The standard. Yeah, okay. Oh, look, I mean, I guess I'm encouraged that you do think it's an issue that if we've got the opportunity to address, then it's a good thing to do. And if we can keep the standards as straightforward as possible, then I think, you know, I think there's no real harm in it, really. But that's just my tentative view, so that's helpful. Thank you.
Yes, and certainly, Erica, for me, I'm on the same page. I think there's this important test of practicality and certainty around any permitted activity standards linking to the outcomes that are being sought. So I think we did talk last time when we heard this evidence about the fact that the habitat is very mobile in this case, and you've already got existing significant nodes with lighting which are important for safety around the port and certainly around the airport and things like that. So it would need to be quite carefully constructed. I am certainly a fan, if you are going to be using guidelines for referencing standards, that you actually take out the key parts of the standard and put them in the plan that you think are workable, rather than cross-referencing to a document which may or may not be updated and all those sorts of things. So I think it is good practice to think about if there's applicable guidelines there that might be useful, given the practicality, the certainty tests that you'd have to think about. Yeah, we'd encourage you to think about what might able to be done, and again within reason, I think, is my feedback. Yes.
No,
Thank
completely
you.
agree. Thank you for your feedback and noting in the memorandum. So that's helpful. Thank you. So moving on to the second and last main point that I'll cover for today is from Te Kautahitanga o Te Atiawa. So this was around the wording of objectives and policies in relation to the cultural values of the night sky. So I accept and agree with the submitter's evidence that sought to amend the reference to the views of the night sky, including its cultural values, to instead refer to the views of the night sky and the cultural values of the night sky in light O2 and P2. I'll recommend this change as requested in a written right of reply. And that's the two main issues that were raised in the discussions in the hearing. Were there any other matters that you'd like to discuss now that I want to address?
Yep. Yeah, I've got a few. If you want, is that okay, Stephen? If I
Yeah,
kick off?
go for it, Kit. Yep.
There was quite a bit of toing and froing with Doc over how you deal with light from port and aircraft operations. Is it still the case that you're sticking to your recommendation in terms of how you address those in your Appendix 1?
Yeah, so that was also raised by TRTO in their submission, but not their verbal part of the hearing. So I agree that operations could be construed too broadly, especially because airport activities and port activities as defined in the plan is very broad. So we can't rely on that. However, I think that the proposed wording that they've raised kind of has the same issue of being slightly too broad. However, looking at the dark sky provisions in Southland in particular and a couple of other areas, it could be further refined to refer to navigational aids instead of operations. That's what has been done in other districts. My only concern there is that it might be good to check with the port and the airport to make sure that referring to navigational aids covers what they need it to.
Just to follow up there, Erica, the port and airport, they aren't further submitters on this matter, are they? So they haven't picked up the issues around the request from the Director General, have they?
No, so yeah, the only feedback we got was for the Section 42A report in which they agreed with the recommendation originally, but
Yes.
haven't responded to the Director General of Conservation matters raised.
No, but they don't have scope to respond really in evidence.
No,
do they?
I guess it's just a matter of accuracy and making sure we get it right.
Look, Erica, I think it is good practice, even though they are not further submitters, for you to check with them, just so you understand, as you say, the accuracy of the effect on them, which is part of the current situation you need to think about when you make your recommendations. So I'm not saying don't do it. I'm just double checking that they weren't involved, which was my working assumption. Yeah. Thank you.
Yeah, can I just talk that through? Because in the rules is notified, the activities in the airport zone and activities in the port zone were just covered by the same standard, weren't they? And you've recommended in your 42A report an exclusion for lighting associated with aviation operations and aircraft. Who suggested that if neither the port nor the airport company were involved? Was that you just responding to a submission that said that the airport and the port ought not to? Well, I don't. Can you just clarify that? How did you come to that change?
Yeah, sure. I also note that Hamish has turned on his video, so I'll do a quick run over and allow him to cover any gaps. So we had a stab at creating some wording that we thought would be appropriate in terms of restricting it to aircraft, which is obviously to do with navigation, and the maritime navigation as well. Hamish, did you want to add anything else in there?
Yeah, so you're correct, Erica, in that there was no further submission on the Director General submission, but the port and the airport in their own rights made submissions on the light provisions, both the policies and the rules. So that's where the primary exemption originally came from. So we've got scope there to change the.
No, that makes sense. So thank you for clarifying that. I had the sinking feeling that you were making changes that no one asked for. But no, so that's made that very clear. Okay. The other thing I wanted to have a bit of a chat about is just how some of the, as you've added things to these policies and the objectives, they've become quite chunky, to use a technical term. So, and in some senses, when you run off a list of things using commas, you can get the syntax can sort of change. And so, I mean, if you've got your recommended light O2 there, and I know you've accepted that there's a difference between views of the night sky generally and the cultural values associated with the night sky. So you're going to presumably have a think about where, or if at all, if you need brackets. But I just cannot stress enough to read the words really, really carefully. My old Latin teacher at Boys High always used to say, read it once, read it twice, read it 3 times, because the more you do so, you realize what you're trying to achieve there. And so the preface words sometimes don't really make sense if you read them as a list. So all I'm saying is just make sure you're very clear, and sometimes the and can be in the wrong place, or you need a comma just to make the whole thing sort of make sense. And it may be that the way certain things are expressed needs to end up earlier in the writing. So that's just me being a grammar Nazi. So I'm sorry. I'm sure you'll focus on it and try and keep them.
I'm a little bit that way inclined myself.
All right. So just and that the shorter and sweeter you can make the policies, the easier they are, and the less opportunity there are for people to get into arguments about what's being meant. And if that means adding on another sub paragraph to create a different concept, then feel free to do it. Don't keep adding on and on and on. I mean, lawyers have been told for years that they write things too long, so and they still don't listen, but they do it anyway. So the only other thing I wanted to just have a quick discussion about is the way you've got you've added in the exceptions to light R1. So you've got here, this rule does not apply to light associated with aviation operations and aircraft, and light is necessary for navigation and shipping. In the standard though, you've still got the airport zone and the port zone. So the way we read, is the way I'm supposed to read that all other lighting in the airport and the port zone that's not captured by the exclusion still has to comply with the standard.
Yes, that's correct.
Got it. Okay. Yep. So, for example, the port couldn't turn on all of its big floodlights for fun one night if there wasn't a ship in port that they needed to load or unload.
Effectively, yes. Or
Okay.
In the instance of the airport, you don't need massive flood lighting for the car park.
Yeah. Well, that's right. Okay. There was a suggestion about, in terms of standard 1, bringing the multi-purpose zone out of the sub 2 of that up into the sub 1. Had you had any thought around that?
Yeah, so I looked into this a bit more. I've written a little bit of a spiel, which I'll just read out and let me know if you have any questions at the end. So the appropriate light rules and standards will obviously largely be determined through the aspirations of Māori for the land that they have, and that can vary across the district. However, looking at the standards as they are written now, the same light spell standard of 10 lux applies to the multi-purpose zone as also applies to the residential and the rural zones. As the submitted notes, however, the site boundary method is used for measuring light spill in the residential zones, and the notional boundary method is used in rural and multi-purpose zones as currently drafted. Looking at the provisions of the multi-purpose zone, it can certainly accommodate sensitive land uses such as marae and papakāinga and kaumātua housing at a higher intensity than typically found across rural zone productive properties. To protect the future aspirations of Māori to use their land for potentially sensitive land uses, I do agree it is appropriate to align the multi-purpose zone light standards with that of the residential zone in light S11.
Okay. All right. So you'll bring that up so that it's measured at boundary rather than notional boundary.
Yeah, I think that might be more appropriate.
All right. No, that was it. Thank you, Erica. It was helpful.
Thank you very much, Erica, and thank you for your assistance.
Cool. Thank you.
Afternoon, Commissioners.
Afternoon, Mr. Wesney.
So for noise, we've heard a lot of evidence and a lot of questions from yourself to the submitters about noise. So what we'll do is step you through the main issues that we heard, and we'll do it in two parts. So I'll take the first part and deal with issues that were primarily raised by the oil and gas sector, relating to the wording of the objectives, site boundary.
Come on about noise. Noise already? Yep.
Cam, you just got off mute. Oh, yeah. Site boundary versus notional boundary, and the noise limits. And Mr. Lloyd will comment on those matters as well. And then the second part, Ms. Gardner will take you through responses to the Defence Force, Southern Cross Hospitals and Powerco, with Mr. Lloyd also commenting on those matters.
Thank you very much for that. Yep.
And just in terms of how you've run with Erica, we'll do it in the section. So I'll start with the wording of the objectives, and then happy to take questions on that first before we move to the next topic. So in terms of wording of the objectives, Greymouth Petroleum contended objective noise O2 applied an absolute threshold of no adverse effects. As we outlined in our section 42A report, do not consider this wording to be absolute. Because that objective uses the phrase adversely affect, which recognises a form or some noise is anticipated. We also consider that the notified wording, which provides greater clarity than the avoid, remedy or mitigate wording, which are more general terms, and it's not always clear how that string of three are to be achieved, including whether there's a hierarchy or whether there's a preference towards one or more of those. The second matter related to the objective 3 around avoiding reverse sensitivity effects rather than minimising reverse sensitivity effects. Avoid is a very high threshold, and the proposed plan currently does not seek to avoid reverse sensitivity effects, and recognises that's not always possible. We consider minimise as a more realistic and achievable outcome, given the diverse range of activities which generate noise. Designing or locating noise sensitive activities to avoid reverse sensitivity effects could place significant restrictions on the use of land or costs on developing noise sensitive activities. However, we note in minute 9 from the independent hearing panel in your interim guidance that the strategic direction objectives, you've proposed a new strategic objective for infrastructure and energy. So your new objective IE1 seeks to ensure reverse sensitivity effects are avoided for infrastructure. In addition, in your interim guidance for the rural environment, for objective RE2, which relates to highly productive land and natural, physical and cultural resources in the rural area, that you've amended that to protect from inappropriate activities. So one's use of avoid, one's use of protect, so that's two high thresholds there. Also in the rural production zone generally, in the current objectives, it refers to not limiting, restricting or compromising productive or rural industry by incompatible activities or reverse sensitivity effects. And also another objective relates to sensitive activities being designed and located to avoid, remedy or mitigate adverse effects. So taking all of that direction into account, if you are of a mind to use the term avoid in noise objective 3, our view is that further plan provisions would be required to achieve that noise outcome, that avoidance outcome. To do that, we consider more directive and stronger policies would be required to avoid reverse sensitivity effects, particularly on infrastructure and rural resources. In addition, some further regulatory measures would be required for noise sensitive activities, such as setbacks or buffer areas from existing infrastructure and energy activities. So that's our response to the objectives that were thought to be changed. Any questions on those matters?
Yeah, I did. Noise 03, I mean, putting aside the issue about the standard you're imposing, whether it's minimise or avoid, I'm just interested in after the minimise at the moment, you've got two terms. One, you've got conflict, and then you've got reverse sensitivity effects. And I don't know how to read that. I got to say, I know what reverse sensitivity effects are, but I don't know what the conflict's does the effects word at the end, is that a qualifier for conflict? So we have minimize conflict effects, or is conflict just a general concept? And if it is, I just want to know where it where does it come from in the context of resource management? I mean, we all know what reverse sensitivity effects are, and so I guess I want to get a bit more of an understanding of why you've used this term, where it's come from.
Yeah. So another word for that conflict in that context could be incompatibility. So that's where, from a land use perspective, you've got activities which are generating noise or creating effects, and then activities which are the receiver of those effects. And when you've got those two types of activities which are incompatible with each other, that's the conflict there. And in my view, you cannot always avoid that conflict, or if you're seeking to avoid that conflict or that incompatibility rather than minimizing it, you cannot always avoid it, or if you are to avoid it, then the measures you need to do to achieve that.
Yep. Okay. No, I get that now.
Measures.
So you're using conflict as a single word to describe the concept of minimize the co-location of incompatible land uses, or minimize conflict between land users. Yeah, okay. I'm just wondering whether you might need to sort of flesh that out a little bit, because conflict, just have to think about it. You might be, everyone might know exactly what you're talking about, but I'd scratch my head a little bit, but I get the point that it's about trying to make sure when you do land use planning and consider things, that you don't have the chicken farm next to the daycare centre sort of thing. And I mean, that's a very sound concept. I just wonder whether that word captures it, but it might just be me. I just thought I'd raise it.
Any other questions on objectives? Yes, Hamish, a question that you understand, or I think you understand, that the interim guidance on strategic direction objectives are fluid. They come back from the panel as some guidance to be discussed and debated and rationalised through the detailed hearing chapters. So we've certainly got no problem if in your written right of reply you obviously outline the way you see these relating to the chapter specific objectives and policies, and maybe provide some other suggestions about what could be another way of dealing with that particular strategic objective you highlighted, including suggesting some different wording. We're very open to that, so that's part of the interactive process. So I just wanted to clarify that. And is that okay? Is that clear?
No, it's helpful to understand. That's why I did take the opportunity here, just to flesh out what some of the implications of how they're currently worded, what it might mean, and how that then influences the plan.
That's excellent. So thank you for that. So if you outline that in the written right of reply, we can have that on record.
Okay. So I'll move on then to probably the matter that had the most evidence presented on it regarding site boundary versus notional boundary. So the noise measurement location for the rural production zone. So I'll just summarise what we heard, just to set the context for that, because there was a number of the noise generating activities, or submitters that operate noise generating activities. In my view, had three main points that they highlighted, which was that they consider the current notional boundary location is working efficiently and effectively. They queried that, or contended that there was no or limited evidence to support a change to the site boundary measurement location. And thirdly, that a change to the site boundary would significantly constrain the noise generating activities. We also heard from Te Atiawa in terms of their concerns about noise being generated. And again, I noted three main points that they made in terms of Māori land as a tonga of special significance to tangata whenua, and that they have a living relationship and connection to their ancestral land. That this living relationship does not always include a building against which a notional boundary can be applied, and that this lack of a notional boundary limits the consideration of noise effects, in particular the relationship of Māori with their sensitive areas such as Waitapu, Urupa, and other places of solace, where, and this is a quote from the evidence, Māori are able to be Māori. And then thirdly, they contended that these reasons were special planning reasons for consideration of the site boundary approach. And also, just to set the scene on this one, there was some criticism of council regarding the lack of consultation in terms of reviewing, preparing the proposed plan. And I'm aware that commissioners heard at the first hearing what the process was for preparing the plan. So I don't propose to repeat that, but I just wanted to highlight that most of the submitters on this matter were engaged and did provide feedback on both the two versions of the draft, and also that there was direct consultation with a number of parties who operate in the rural environment, or industry associations for the rural environment, such as Federated Farmers, the poultry industry, the egg producers, Teagle and Balanced Fertilisers. So we do have an understanding of what their views were on this matter.
Just on that, did the draft plan have the site boundary rules in it, or was that?
Yes.
Yes, okay, so it started off as using the site boundary, okay.
So I'll hand over to Mr. Lloyd, so he'll take you through his acoustic advice on this, and then return back to me to give you the planning response to the evidence heard.
Thank you, Hamish.
Good afternoon, everybody.
Good afternoon.
So this is my 4th week of hearings and the first time I've managed to appear. So excuse me if I'm a little on edge.
We've seen your name up on the screen all through, and appreciate that it's difficult, particularly as an expert, where your views are being challenged, just biding your time to be able to have your own say. So welcome, and we're very interested in your advice, Mr. Lloyd.
Thank you very much. So the national boundary noise measurement location can result in land that is not owned or occupied by the noise generator from experiencing high levels of noise. This high noise could negatively impact on the use and enjoyment of this land, particularly in the rural context, which are typically quieter environments, particularly away from busy roads and industry. Protecting dwellings, particularly for the health and well-being of the occupants of these buildings, is important and is consistent with the direction in NZS 6802. However, I consider maintaining the amenity of a quieter rural environment generally is an important characteristic. Reference was made by submitters that the site boundary rule sterilises land as it restricts where noise generating activities can locate on a site. I consider the same comment applies to the notional boundary approach, in that once a significant noise generating activity is established, which emits loud noise where there are no nearby dwellings, then this situation practically sterilises adjoining land. The principle for the boundary noise limit is to establish if such dwellings could be developed as a permitted activity on neighbouring land to allow them to be involved in the resource consent process before that opportunity is lost. To illustrate this point, there are 2 examples I know of. From a noise perspective, Ngāti Rahiri would not have been notified when the new well site was consented at the end of Epiha Road, because the well site noise complied with the notional boundary noise limits in the operative plan. We heard about this in their evidence. The nearest dwelling to the site was 785 metres from the proposed pad extent, and written approval had been obtained from both the owner and occupier of the dwelling. And site boundary noise limits would have involved Ngāti Rahiri in the process from a noise perspective and allow their aspirations for a marae on the site to be expressed. And I note that Ngāti Rahiri may have been involved in this consent process for reasons other than noise. And I was involved in that, in advising council on that resource consent as a desktop exercise. When the Methanex Waitara Valley plant recommenced production in 2014, complaints were received from a neighbour who was in the process of building a new dwelling closer and more exposed to the plant noise than existing dwelling. So I consider the notional boundary approach alone could impact on the neighbour's ability to construct a future dwelling. If land was subject to higher noise levels due to no existing noise-sensitive activities being near a noise-generating activity, it is unlikely a property owner would choose to locate a new dwelling closer to these higher noise levels, even though they may be entitled to under the district plan. In my view, the site boundary standard provides a reasonable standard for control of adverse effects on neighbouring land. The assessment then shows that the adjoining land is not noise sensitive in any way, and that's an assessment Mr. Hegley stated in his evidence he already undertakes anyway. Then there will be no restrictions on the proposed activity. The dwelling is permitted on adjoining land and the landowner has aspirations for that, then this is important information that needs to be known and mitigated by the developer. The costs and benefits relate to the right of the developer to contaminate the neighbouring land with noise against the rights of the neighbours to enjoy reasonably peaceful amenity values. Site boundary noise limits provide a trigger for this assessment to take place as part of a resource consent application. Overall, in my experience, providing acoustic advice to local authorities in the Central and Lower North Island for policy, consents and compliance purposes, in my view, there is potential for noise conflict and incompatibility in the Taranaki region due to the greater number and distribution of noise generating activities in the rural environment. This conflict is particularly associated with the activities of the oil and gas and energy sector, which involve inherently noisy activities. Now, this comment is not a criticism of the oil and gas and energy sector or the operators in this sector in respect of how they manage noise. Rather, it is an observation of the specific challenges associated with the noise issues and environment in the new Plymouth district. I consider these circumstances would constitute special planning reasons referred to in NZS 6802 as to when the notional boundary alone may not be the most appropriate approach to the measurement location, and the addition of the site boundary is preferred. And I set out a number of the statements in 6802, which might be useful. So it states in 844, there may be special reasons for protecting the amenity of rural land, for example, a natural, cultural, or other reason why an area is accorded some special status which distinguishes it from other land. And I consider this has particular relevance to the Maori purpose zone. In 845, 6802 states, whether rural land not used for human habitation deserves protection against noise may depend on the suitability of the land for future residential development and the existing or future potential recreational amenity of the land. And for completeness, I need to state 845, which says the notional boundary concept recognises that sound emissions are the basis for protection from noise under the Resource Management Act, unless special planning reasons exist to justify using the legal boundary rather than the notional boundary of dwellings, where lot sizes are large and settlement density is low. The appropriate location for assessment of noise in rural character areas with large lot sizes should be at any point within the notional boundary of a dwelling. And this may include some rural residential areas. So those are direct quotes out of 6802. So noise S122 uses the notional boundary to establish the residential amenity standards. But I consider it also important to include noise S121 to make an assessment of the site boundary as part of the consenting process to determine whether it is appropriate to generate high levels of noise on adjoining land. And lastly, if commissioners were of a mind to use only the notional boundary noise assessment location, I consider the well site's drilling standard, noise 2.4, is superfluous. The Section 42A report recommends that rural production zone maximum permitted nighttime noise limit be amended to 45 LAEQ 15 minutes, which is the same as the well site's drilling standard. I note that this 45 LAEQ 15-minute recommended night relaxation in the Section 42A report is only for receivers in the rural production zone, and that noise levels received in the Maori purpose zone, rural lifestyle zone, future urban zone and or residential zone should continue to meet the 40 dB LAEQ 15-minute standard. My understanding is that Mr. Ellerton agreed with this in his response to the Commissioner's questions. I can ask questions about that.
So I'll ask you some questions just about your experience through various councils and hearings regarding this, I'll call it a contest between the experts about what's appropriate. We've heard that there was a recent mediated consent order in South Taranaki District Council. You were involved in that?
That's correct. And Hamish was there too.
Yes, right. And we've been given plans from around the country about districts which use the site boundary as opposed to the notional boundary approach. And it seems like a vast majority of councils are using the notional boundary. Is that your understanding as well?
Yes, correct.
Yes. So are you aware of or have you been involved in any environment court cases where this matter has been dealt with and determined by the courts?
No.
Okay. So
there's other acoustic consultants tend to say that there's plenty of case law which says that the notional boundary, the court has accepted the notional boundary is the appropriate location to undertake these assessments. But I'm not sure how contested they've been as to whether they're acoustic consultants or a combination of acoustic consultants and planning evidence, because I see this as a lot of this is a planning issue really, rather than purely an acoustic consultant's opinion.
A planning issue with acoustic advice,
yes.
Is that how you frame it?
It is.
Yes. So I am particularly interested that there is, would you agree that there is quite a marked difference of approach between the site boundary and the notional boundary approach? There is a significant difference between the two.
So there is a significant difference between the two, but the effect can be the same. It depends on each individual case as to the distance of the notional boundary from the site boundary.
All right. You would listen to our questions of many of the planners about their experience in New Plymouth District and them thinking about, are there any real sort of planning reasons or cases or opportunities where the notional boundary wouldn't be effective? You've used a couple of cases, the one I think at Ngāti Rahiri and that well site. None of the other people we've spoken to have been able to give us examples of where, say for permitted activities, houses could be developed in the rural production zone nearby. It's a permitted activity.
So Hamish is going to deal with this shortly, I think, but there were other situations at Kowhai C well site where that situation did occur too.
Okay.
The problem with this is that you're talking about the district as a whole, and that what you're getting is unusual things, unusually noisy activities that are occurring could occur anywhere in the district, and they do on a piecemeal basis. And they're certainly concentrated where it's advantageous to do well site drilling, for example, in the first instance. But these are almost ad hoc situations, and you're trying to predict where these situations are going to occur in the future. And my argument is that you need to take a precautionary approach when you're trying to write district plans to control these activities that you don't really know where they're going to occur or what's going to be near them or what could possibly be developed in the future in that area.
Right, I might ask Mr. Wesley some other questions about that when he comes back to us, but certainly my understanding is we aren't operating in a precautionary approach situation with the RMA per se. So
well, I think when you're doing consents, I tend to take that approach.
Okay, so that's your approach as an advisor.
Yes.
Yes. All right. Okay. Well, that's helpful. Your position is clear. I'll just summarise it that you haven't been involved or aware of any particular case law from the courts about this. That's a difference in practice around the country, and you, for the reasons you have expounded, prefer the more cautious approach of using the site boundary. Is that a fair summary?
That's correct.
Thank you. Commissioner Littlejohn.
Yeah, thank you, Mr. Lloyd. I think from my perspective, you sort of hit the nail on the head really when you said that this is less of a noise issue and more of a planning issue. And so in my mind, it comes down to what is the purpose of the zone in question and what is the stated objective for the management of amenity in that zone. And so at the moment, we've got a standard that applies which applies to the Māori purpose, the rural production, the rural lifestyle, and the future urban. And I guess from my perspective, have you had a look through the specific zone statements and the objectives for those zones, or is that not something you were asked to sort of contemplate when you were providing your advice?
That's not something I've been asked to provide them advice on yet.
Right.
So this advice has been given over. My original advice was given in 2014 on this, so it's a sort of had a long gestation period, really. So yeah.
So we should be focusing our questions on those sorts of planning matters and the objectives of the zones and what the amenity outcome that's sought to be achieved in those zones back to the planners themselves.
Yes, Mr. Wesley is going to sum up on this issue. So it could well be that you've got planning questions you should ask him.
Well, I mean, given that you've highlighted the issue as being one of a planning issue, I fear that I've got to ask him because you've said he's a planner. That's right. That's right.
It is a combined thing of the basic acoustics and amenity values and what we're trying to achieve, and my involvement with the New Plymouth District Council in advising them over a long period of time on quite a few well site applications now as to the issues that have arisen in that time. But when it comes to the district plan, that has to be transformed into a planning approach.
Is it the well sites that are the big issue? I mean, you've said you've had a bit of experience with them in Taranaki in New Plymouth District. Is that one of the most notable noisy activities that can occur in an ad hoc fashion?
Well, the well sites are more short-term, repetitive activities. So actually, they do cause an issue when they have the potential to cause complaints when they do set up, but then they maybe finish after 3 months. Probably more of an issue has been over the years, has been production stations and issues, because once they're there, they're set and they operate on a 24-hour basis forever, basically. So they have been an issue, and it's not just them; it's quarries and depots and all sorts of different activities that could also that these rules are meant to control.
Okay,
and they are being sidetracked a little bit by oil and gas considerations, I think. So we have to be a bit careful there.
Okay. All right. No, that's it. I've appreciated your evidence. It was very helpful. Thank you, Mr.
Thank
Lloyd.
you.
Okay. So I'll continue then with the planning response to the evidence we heard. So I concur with Mr. Lloyd's second to last point about the nature and character of activities in the rural area of the New Plymouth district. In my experience, including assisting South Taranaki District Council with their district plan since 2014, the noise issues in rural areas of the Taranaki region are more significant in other parts of New Zealand that I've experienced in. The nature and location of well sites, production station and generation facilities, combined with the nature and level of living and occupancy in rural areas in the New Plymouth district, results in greater potential for conflict and incompatibility between noise generating and noise sensitive activities. A number of submitters commented that there was no or limited evidence to justify a change from a national boundary to a site boundary, with specific reference to a lack of complaints. The complaints record referred to in the Section 32 report, which a few submitters and evidence referred to, was based on a keyword search of the Council's Customer Management System complaints database. However, this complaints database isn't a comprehensive record of all complaints received by Council, and searching via keyword searches doesn't always identify all complaints relevant to a particular issue or not. I think it was Mr. Twigley highlighted that there was reference to one well site as receiving a complaint in the Section 32 report. So that complaint related to the Ko-Fi C well site. This complaint was received in 2013 when the well site was being established or consented and established. The complaint relates to noise effects from the well site for existing and future dwellings. In discussing this complaint and well site with council officers, this situation does highlight the ineffectiveness of the national boundary approach, along with the effects-based approach of the operative district plan as a whole. The resource consent application for this well site only related to non-compliance with the hazardous substances rules, with discretion restricted to the effects of hazardous substances. The application demonstrated that the noise rules would be complied with at the national boundary for existing dwellings that were there at the time of the application. However, the complainant, who was an adjoining property owner, was concerned about the noise generally affecting their property, as well as where they may locate future dwellings on their land. And then just to add to that, I understand following the establishment of this well site, there were a total of 12 noise complaints received about the operation of the well site, and the noise monitoring concluded that this well site was operating in compliance with the resource consent conditions, which applied the national boundary noise measurement location. So I just felt I needed to step you through that because it was referred to by a few submitters.
Yes, and I think we did ask for some information, so thank you, Mr. Wesley. Is that, when you've gone back to the database, is that the only one you've found, or you've found other ones as well? No, so this is one of the challenges, and this is, you might hear this from other members of the council's planning team. The complaints database that council uses isn't comprehensive. So, for example, the 18 noise complaints about the Ko-Fi C well site are on the consenting file for that well site, but not in the council's consents database, or sorry, the compliance database. Okay. Yes, but have you canvassed others in the council about this issue, or? Yes. Yes, and what's their? Is their opinion that there have been other complaints? Yes. Yep. And with that, the next example is
responded to by Todd Generation regarding the peaker plant. So there's similar circumstances there in terms of when it was established, we're going through the consenting process. That noise was a consideration then, with the national boundary being used. And since its operation, there have been complaints about its noise. Again, my understanding is that the compliance monitoring that's been done has confirmed it complies with the noise requirements at the national boundary. But there are still further investigations going into that one around special audible characteristics. So it's just highlighting one of the challenges with the national boundary, where you get new buildings built, and these complaints can arise.
Okay, thank you.
Just on that last example around the peaker, the Junction Road peaker plant, I'd note under the operative plan that was a discretionary activity where the noise effects were assessed of that proposal at the time of the application, and the commissioner who determined that application considered that the noise would comply with the noise limits in the district plan, and considered on that basis that the noise effects would be acceptable. So I highlight that because of Mr. Twigley's evidence, which I found helpful, as well as your comments on and questions of Mr. Twigley. I concur with his assessment with under the proposed district plan, well sites and production stations, for example, would be discretionary activities where the noise effects would be assessed. And in doing that, consideration would be given to the noise rules in the plan and what's anticipated by the district plan for those noise rules. So while it's discretionary and noise effects would be considered, I think there is a anticipated by the plan consideration there in assessing those applications in the future.
Okay, thank you.
So turning to consideration of the benefits, costs, efficiency and effectiveness of the two approaches, we evaluated this in the Section 42A report. And at the start of this hearing, the Commissioners asked Council officers whether they had any points of clarification or queried matters raised in evidence. And I commented at the start, it would be helpful to hear from submitters further details about the costs of the site boundary approach. From the evidence presented at the hearing, the main cost I noted was limiting options where noise generating activities could be located in compliance with the permitted activity standard. So having considered that evidence, my view is that no changes are required to that evaluation in the Section 42A report. I consider that the costs that we considered then in terms of restricting the location of activities, we'd considered the evidence based on what they highlighted. There were no additional costs that were highlighted from my perspective that I hadn't previously considered.
And you would have heard my comments to Mr. Ellerton about the fact that if there's other proposals proposed, the proposers really need to do their own 32AA to give that as evidence. And of course, we haven't got that, except for that particular matter that you've just raised.
Yeah.
Thank you.
So the last point I just wanted to make on this, the Commissioners asked operators about any arrangements that they may have with landowners, which the operators confirmed that they work with landowners when establishing their activities. In my experience, if someone has been adversely affected by an activity, they generally raise the matter with the operator of the activity in the first instance. So that's where, if I'm a neighbour of a property that's generating noise, I'll get in contact with that operator first and see if we can resolve it amongst ourselves. If that is unable to resolve the matter, then the complainant will generally contact the council to see what they can do. And from my point of view, that's an effective approach. If that's, and I understand that has been the case in the Plymouth district and wider Taranaki, where there have been issues around noise, that works in the first instance, and there's ways that can be resolved. So overall, and in conclusion, having considered the evidence, my view is still that the site boundary approach is the most appropriate location for the reasons we set out in the 42A report. So happy to take questions.
Commissioner Littlejohn, do you have any questions?
Yes, thank you, Mr. Wesley. That was helpful. I'm assuming that all of the 42A report writers are going to put this in writing for us eventually. I haven't been scribbling notes, so thank you. I guess the one thing I really wanted to just tease out with you is just the point I raised with Mr. Lloyd about the purpose of the zones. And I've read ahead into the other chapters, and there is certainly on the face of it quite a distinction, for example, between the way the rural production zone is conceived and, by contrast, the rural lifestyle zone. You can see a distinct difference in the flavour, both in terms of the overview of those zones and in the objectives and policies. So to some extent, I could take on board Mr. Lloyd's proposition about amenity of a quieter rural environment that's worthy of being maintained, I think was one of the phrases he used. And in particular, look at the rural lifestyle zone where there is much more of a reference to maintaining that more denser living character, and look at the notion of a boundary control, because it's getting on the spectrum, it's getting closer to the sort of the residential end of the spectrum. But I guess I'm struggling to see where in the rural production zone there is any objective or policy framework that suggests protecting a quieter residential amenity as one of the functions of the zone. In fact, it's almost expressed to be the opposite in a way. And so I really want to get your opinion on where you see the boundary noise control as being consistent with the objectives and policies of the rural production zone.
I understand that, and your exchange from Mr. Lloyd earlier around this, I agree. This is what is the outcome we're seeking to achieve here, and this has been so this particular issue has been a ongoing conversation with the district plan team, and as I mentioned earlier, with feedback on the two draft plans earlier, this was raised. So it has been an ongoing conversation. What are we trying to achieve in the rural areas? And then that obviously influences what the policy direction and ultimately the rules where they're set. So in terms of the rural area, there was a number of reference to it being a working environment, it's production, and that can range anything from just normal farming activities, which some of those are very quiet, hence the inherent nature of a quiet rural area, but there are occasional activities which do generate the noise, and we had reference to milking sheds in New Plymouth, the intensive farming, the poultry industry, and their extractor fans, one of the more have been one of the issues in the past from a noise perspective. So when my reading of the proposed plan at the objectives level for the rural zone compared to, say, the other ones, it does recognise that as a more working environment. Therefore, you'd expect higher noise, higher noise levels. But also, it does recognise that as a place where people live, and whether that's because that's where they work as well, or it's because of where they choose to reside, and that's where I'll describe it as the hybrid approach, where the noise standards and the measurement location work in tandem. So the site boundary rule has a higher noise limit than the notional boundary rule. So that to me is how the rule recognises the different outcomes, or the overall outcome for the rural areas, that there is anticipated to be noise-zero activities, where the site boundary and a higher noise limit of 55 is provided for, along with the national boundary concept, recognising the sensitivity of where people live. It's more sensitive to noise, particularly at night time. So that's where I'm taking my guidance from. Is that it is the working environment, so there is a higher, similar to the industrial and commercial areas, but also there's a place where people live. So it's got those two aspects to it.
Yeah, I just test. I mean, that's a helpful clarification there. So you're referring there to the noise S1 too, where in the rural production zone you've got a boundary limit that's set at 55 dB, whereas your notional is at 50 for the effectively for the daytime period.
Yes.
Yeah. Okay. So you've endeavoured to accommodate the sensitive activity occurrence within the rural production zone by giving it protection, but not a lot of protection in a way, because 55 dB during the day could be construed as relatively noisy, couldn't it?
Yeah, and especially at night, so that 55 applies at all
Well,
times.
yeah, that's right. But yeah, okay.
And
Just I still come back to objectives, for example, with the rural production zone, where objective 7, sensitive activities are designed and located to avoid, remedy, or mitigate adverse reverse sensitivity effects and or conflict with primary production. So the signal is clearly given to the sensitive activities that they shouldn't come there and expect a high amenity level, and that if they're going to go there, then they need to solve that problem themselves. And it's sort of saying that the primary use is the noisier use, and that those who want to come there and live there are going to have to take second fiddle to that. So I mean, I've got a slightly better picture now of the way the hybrid approach works, but even so, aren't you sort of shifting that balance in the primary production zone and putting the protection of amenity at the cost of protecting amenity back on the primary producers?
No, yeah, that is all about finding that balance, and so that's what I see the rules doing. So you've highlighted objective 7, which is about sensitive activities and how they are to what they are to expect. But I also think objective 5. So we highlighted this in the 42A report, that it is that functional, productive, extractive orientated working environment. So that's very much supportive of activity taking place that generates noise, for example. But then while ensuring that the adverse effects are appropriately managed. So it's not unfettered, it's not an unlimited amount of effects you can do. So that to me is where I
But there's an and at the end of that one though, Mr. Wesney, which suggests to me that in the same breath as managing adverse effects from primary production, you have to do so in a way that doesn't limit, restrict, or compromise that production by incompatible activities or reverse sensitivity effects. So, it's not.
So that's where I read that 0.1 branch as saying, okay, we need to, those effects generating activities need to be within certain limits, and then vice versa, if there's incompatible or activities that are sensitive that come into those locations, they need to manage, they need to have a certain level of expectations, and there'd be different methods to then achieve that branch of the objective.
I might have agreed with that if you hadn't used the word "and" between those two. But anyway, I understand where you've come from, and I suspect it couldn't have been an easy one to debate, given the range of interests that the rural environment in Taranaki supports. I mean, I think you're right. It's quite a unique region in a way, with a very sort of strong traditional farming and rural production base, but with all of this other extractive and production based activity that's occurring. It's quite a unique mix for a rural environment to have to accommodate. And all along the way, you've still got people who are really desirous of living in that quiet, green, and uncluttered environment. So yeah. Well, I think I've got a much better handle now on where you've landed on all of this, and it's something we'll deliberate on, I suspect. Thank you.
So have you got any other matters for us, Mr. Wesney?
So there's a few other matters.
Yep.
So there was evidence around the daytime, evening time, and nighttime noise periods, and whether there was a need for an evening period. So our response there is that introducing an evening period is based on the recommendations in the New Zealand Standard. Evening times are important for amenity, being times when people are often at home and relaxing. The ambient sound levels normally exhibit a gradual fall of ambient sound from 6 p.m. onwards until particularly quiet towards midnight. So based on this evidence and the evidence we heard, we remain of the view that the evening period is an effective method to achieve the amenity outcomes anticipated for the rural environment. And if the rural production zone night time limit from 10 p.m. to 7 a.m. is changed to 45 decibels as we recommended, then this would apply from 7 p.m. through to 7 a.m. So there'd be some simplification of the standards as they're written there.
Okay.
The next point I'll hand over to Mr. Lloyd to respond to is around the noise limits for the major facility zone and the hospital zone.
Thank you. So before I do that, just on the previous point, there was, I just want to remind everyone that for the rural production zone, there are exemptions or agriculture, horticulture and pastoral farming activities undertaken for a limited duration and are exempt from the noise rules in the district plan. So those primary production activities, if you like, are actually identified in at the start of the set of rules as noise rules and effective standards, which the standards do not apply to them. So just thought I'd make that clear and remind people about that. So moving on to major facility zone and hospital zone.
Sorry, Mr. Lloyd, while I've got you there, we've also got.
Shouldn't I?
No. Yeah, we've also had added into that list of exclusions, because I must say I hadn't lighted upon that one, general animal noise. So once you get rid of the exclusion in 4 and the proposed noise of animals, what are we left? What sort of noise generating activities are we left with in the rural zone? And if we go through your list before, we've got quarries, we've got depots, and then we've got well sites, production and generation stations. Is there anything else?
Oh, it could be a myriad of things.
Oh, yeah, okay. Well, I guess
one thing I've been surprised about is how many different types of things can make a noise. Basically, I mean, a lot of them are. You could have things like childcare centres, or dog kennels, or all sorts of weird things. Yeah,
another favourite one.
Yeah, and the standards aren't very good for controlling dog kennel noise because of it's more annoying than try and avoid them these days. But
yeah, I mean, I just when you pointed that out to me, I had this feeling that we're tailoring a noise rule for the rural production zone that only applies to petrochemical related activities, because everything else that happens there is excluded. But I think you're right. There's probably a lot of other stuff that happens that falls outside of the exclusions that you'd normally expect. So anyway, carry on. I just wanted
the common on that point. The common one is a lot of them are depots, which can be. And they can be quite varied, and then you could get depots which have maintenance for vehicles and even crematoriums, and all sorts of strange things can occur. So which the rules would need to be fit for, really.
Okay.
So I'm moving on now to major facility zone and hospital zone noise limits. And Mr. Allerton for Energy Resources Aotearoa contended the proposed noise limits between the site boundaries of major facilities zone are too low and should be increased. And this relates to noise S182. Based on sites currently zoned major facility in the proposed district plan, this rule primarily relates to the Omata tank farm. But this rule could apply to other sites in the future if they are rezoned to major facility. Mr. Ellerton recommends relaxation on the basis that there are internal site boundary limits in the tank farm in different ownership. And I note noise sensitive activities and non-complying activities in the major facility zone. So the noise limits recommended by Mr. Ellerton, and that's 80 dBA LAEQ 15 minutes and 90 dB L max, are unusually high, and it would be preferable not to have any noise standards between major facility zone sites than to have such relaxed limits in the district plan. These high noise limits could be used when applying Section 16 duties to argue such high noise levels, such levels of noise are reasonable. The noise level of 85 dBA LAQ is considered to be the level at which long-term exposure would start to cause damage to hearing, and at which hearing protection would need to be worn. And I do not consider that 80 dB LAEQ 15 minutes and 90 dB LA max are appropriate site boundary noise limits. In noise S183, Mr. Ellerton recommends that the daytime noise standard is 50 dB LAEQ 15 minutes, which is stricter than the proposed plan. The numerical maximum guideline limits in 6802 are what are used to control noise from major facility zone. This is to outside the zone, and these are considered appropriate and should be retained. The application of the site or notional boundary is discussed above and is appropriate to apply these limits at the site boundary. Happy to take questions on that.
I just need to understand, Mr. Ellerton's point was that in the tank farm there are a whole range of different internal sites, and I understood he was suggesting there wasn't those internal sites the noise limit should be set. It should be on the outer perimeter. Is that as you understand it?
Well, no, I didn't understand that. I understood that he wanted a much higher limit between those, a much less strict limit between those internal sites. But if that's the only issue, I don't think we should have any limits at all. We shouldn't just, you know, I think we've done that in Wellington, in the port, where there's lots of sites that are owned ostensibly by the same organisation, which we've tried to say, well, that there shouldn't be control, there shouldn't be, the limits shouldn't apply between those sites.
Mm.
And then
is that more of a planning issue around the definition of sites, perhaps, Mr. Wesney?
Yeah. Yes, I think that would come into it in terms of what is that, how it's owned and operated. Is it a collective of collective activities, which could be defined as a single site under the district plan.
Okay. Well, I think if you could just
we'll clarify that.
Check on that with Mr. Ellerton, just so that we're not creating a nonsense of within a site having to, within an overall facility, having to have internal site controls that don't make any sense.
I'd agree.
Right. So the final matter, before I hand over to Holly to take you through the other submitters, was in relation to the rural production zone, rural lifestyle zone being split off from the future urban zone and the multi-purpose zone, as well as what's the most appropriate noise rules and standards for the multi-purpose zone. And Commissioner Littlejohn, similar to your question earlier to Erica Jane around light, what's the appropriate light standards for the multi-purpose zone? So in our view, from a noise perspective, the noise outcomes are similar for these four zones, and that they are generally quieter environments, but they do have activities which generate noise. The future urban zone, and you'll hear more evidence on other topics about this, is effectively managed as a rural area until it's rezoned to another purpose, such as residential or other urban zoning. And as Commissioner Littlejohn questioned or had discussion with Mr. Holswich around how the Māori purpose zone noise standards currently work. That provides flexibility for activities to operate and generate noise, but also it protects surrounding activities which may be sensitive to that noise as well. So it does those two things. So in our view, that those four zones are appropriate to be grouped together and apply the same noise standards to. But that's with the preface, I think, for future hearings, what you decide on the Māori purpose zone in terms of its primary, the outcomes that sort. Is it a quieter environment or is it a noisier environment? That will influence ultimately what the noise standard rules where it best fits. So on that basis, we don't consider any splitting should be done at this stage. It should just be left as is.
Okay. It's clear to me, Commissioner Littlejohn. He's fine. Yep.
Okay. I'll hand over to Holly then to respond.
Thank you very much for that, Hamish.
Oh, thank you, Hamish. Good afternoon to the commissioners, submitters, and any members of the general public that are here this afternoon. As Hamish noted earlier, I will speak to some questions that have been raised around the New Zealand Defence Force temporary military training activities, the submission points raised by Southern Cross and Powerco. So firstly, a question that has been raised is whether the two-tier approach proposed by the New Zealand Defence Force, whether this is the most appropriate approach for managing noise from weapons firing and the use of explosives. So rule noise R9 controls noise from live firing of blank ammunition and or the use of explosives in battle simulations for temporary military training activities. The Defence Force seeks a two-tier approach where the setbacks are applied, and if these setbacks are not complied with, the peak sound pressure levels apply. We're currently seeking to map these setbacks for the New Plymouth district. That is to gain a better understanding of the efficiency and effectiveness of these setbacks in the New Plymouth district. However, based on the initial mapping that we've done, it appears that there are very few areas where weapons firing could take place in compliance with the setbacks, which does question the efficiency of including the setbacks in the rule. I'll hand over now to Mr. Lloyd, who will comment on the appropriateness of the peak sound pressure levels proposed.
Thank you, Holly.
So this was the evidence of the New Zealand Defence Force and Mr. Humferson. And he talked about using peak sound levels instead of using LMAX sound levels. As stated in my original evidence, my issue is not with the noise level itself, rather that people who hear even distant gunfire, and that's termed battle simulations, will be perturbed or frightened. Based on the evidence from New Zealand Defence Force, I understand they proactively communicate to the community prior to these activities taking place. And while this evidence provides me some reassurance, I still hold reservations about the nighttime noise limits, which are still likely to wake neighbours and cause consternation, even if the event can be reliably communicated prior to it taking place. The use of nighttime noise limits is unlikely to be effective in avoiding this. In terms of the daytime 7 AM to 7 PM limit, I agree 70 dB LA max in noise R92 can be replaced with 95 dBc peak to effectively manage this type of noise during daytime. Mr. Humferson referenced the Malcolm Hunt Associates report. Note that Mr. Hunt reported that for battle simulation, the LA max was measured at 5 decibels less than the Z-weighted peak sound levels. For battle simulations, therefore, the nighttime limit proposed by Mr. Humferson of 85 dBc peak would approximate to an LA max of 80 dB. Given that this noise is likely to be quite noticeable at night and that the character of this noise could be perturbing to people, I consider that weapons firing explosives and battle simulation noise below 85 dBc peak would be disturbing and inappropriate between the hours of 7 p.m. and 7 a.m.
Thank you, Mr. Lloyd. So based from a planning perspective, based on the noise evidence from the Defence Force and the advice from Mr. Lloyd, I recommend that the noise limits be amended as noted by Mr. Lloyd. The evidence from the New Zealand Defence Force on prior notification and communication of these activities provides some reassurance. The proposed district plan currently only requires council to be notified of the exercise, and there's no obligations to notify adjoining property owners or occupiers or the wider community. It would be difficult to write a permitted activity standard requiring this notification beyond council, as it would be subjective to describe and determine who is effective and how they are notified. Accordingly, I do not recommend any further changes to the provisions about notification or communication of these activities. The Defence Force also suggests an alternate rule structure, and we will review this structure within our written right of reply. Did the commissioners have any questions regarding the temporary military training activities before I move on?
Not for me, thanks. Thanks, Holly.
Cool. So turning to Southern Cross hospitals, the question that has been raised is whether there should be an exemption from the noise rules applying to generators for major healthcare facilities, or whether this exemption should be applying to the hospital zone or activities in that zone. So having heard the further evidence from Southern Cross hospitals on this matter, we recommend that the exemption be amended to refer to the hospital zone. It is considered reasonable to allow for this noise in the circumstances described by Southern Cross hospitals. We prefer the hospital zone wording as it is more specific to in reference, and it would provide clarity and ensure any potential confusion regarding the use of major healthcare facilities wording is avoided. So now turning to PowerCo, having heard the further evidence from PowerCo earlier this week, we note it is still unclear whether existing gas distribution infrastructure will comply with the proposed noise rules, or whether the noise limits as proposed will pose any compliance issues for PowerCo. We confirm that we remain of the view that gas distribution infrastructure should not be exempt from the noise rules. And now that concludes our verbal right of reply on the noise matters. There was a lot covered there, so commissioners, do let us know if there's any further questions.
I suppose, Holly, one question I have about the PowerCo position, they didn't seem that they've been doing baseline or ambient measurements and baseline measurements, and they weren't aware. So would in your role as a reporting officer, you'd need that type of evidence to be able to change your recommendations, wouldn't you?
Yes, that's correct.
Yes. So without them giving that evidence to say there was an issue with the current noise limits, as you say, I think you are hamstrung by that.
Yes, yeah.
Yes, so I appreciate that. And no, look, I've listened carefully to your explanations, which are nice and precise and clear to me. I don't have any further questions, other than perhaps just checking back with, maybe you can tell us, or Mr. Wesley, that will there be, you're reading for some notes, will they be separately provided to us, or will they be assimilated into the Section 42A right of reply written response? What's the best way of doing that?
I think we do intend to provide a written formal response, but if it's helpful for the commissioners, I don't see why we couldn't provide the notes that we've prepared for today. Yes,
I think the officers have done that previously, so that is helpful.
Yep.
Because it does focus our mind on the verbal response and the matters that you've really concentrated on. So Thank you for that. Commissioner Littlejohn.
Yeah, it wasn't on any of the matters you did address us on, but it was something that came up ironically in the context of some evidence around the Earthworks provisions. And I don't know whether you were online last week when Ms. Ratt for Transpower was contending for the Earthworks provisions to be moved up into the energy chapter. And I think we had a brief conversation in which we went back to the National Planning Standard and had a quick look through there. And I think I sort of observed that it seems to, based on her argument, there are potentially 3 district-wide chapters that could arguably live with respect to energy in the specific energy chapter. One was subdivision, the other was earthworks, and the other was noise. And I just wanted to get your view, and maybe that Mr. Wesney wants to join in, as to whether you think, what was that? And was that something that you thought about when you were constructing how the district-wide chapters were going to work, and explicitly ruled it out, or did it just seem that following the standard and putting noise in one place, regardless of who was causing it, was the better way than splitting it up between who was causing it, you know, by reference to the energy chapters and those sorts of things?
Hamish, would you like to respond? I see you turned on your camera there.
Yeah, so it was something that was considered, and obviously this was one of the first, if not the first, plan prepared under the planning standards. And on the face of it, the reading was that all the noise standards, whatever activity it related to, they all had to belong in the noise chapter. But yeah, I was listening with interest to your exchange with Ms. Ratt the other day, and so we will need to review those subtle wording differences you highlighted, just to see does it fit? Is it fully in line, or could there be some movement of the noise standards to other district-wide topics because they they better sit within those other activities and have a cross-reference the other way. So yeah, so we will look at that and write a reply.
All right, thank you.
Thank you, Holly and Hamish. I think we've worked through the noise verbal reply. Thank you for your help.
Perfect. Thank you.
Kia ora, Commissioners and all other parties. I'm Ali Gibson, and I'm the author of the Section 42A report for signs. So in my reply today, I'll be covering evidence that was presented by Mr. Brophy for Blue Haven, Ms. Barr for the oil companies, Mr. Ellerton and Mr. Ekdahl.
Thank you.
Okay. I've grouped the matters that remain in contention into 6 key issues, and they are the permitted minimum separation distances between signs, the permitted maximum height for freestanding signs, use of the term architectural features, sign face area for signs on buildings, veranda signs, and signs on heritage buildings. And I'd also like to comment briefly at the end, perhaps, on construction hoardings, given the discussion between Commissioner Littlejohn and Mr. Brophy. All right, so each of these matters is fairly discrete. So if you'd like to stop after each one and we can perhaps have a discussion, that'd be great. So first up, the permitted minimum separation distances between signs. And the plan reference here is a fixed standard sign S9. So Ms. Barr for the oil companies and Mr. Ekdahl opposed the minimum separation distances between signs. And you may recall in my Section 42A report, I recommended rejection of those submissions and others in favour of the guidance of Waka Kotahi in its Traffic Control Devices Manual. And this means that the standard has within a 50 km/h speed zone, that signage is limited to 1 sign per 50 metres. Now, I agree with Ms. Barr and Mr. Ekdahl that the standard is impractical for sites, particularly in the commercial and mixed use zones, where frontages are narrow. I think it's unrealistic to expect only one sign every 50 metres when it's not uncommon for sites to have only 7 metres of frontage in the city centre zone. And I'm particularly concerned that the standard gives rise to a scenario where all permitted activity signage on a site would require resource consent by triggering this effects standard. This is an unintended consequence of the standard as drafted, and I don't think the resource consent planners would be very happy with us to continue with it. And I also note that the guidance of Waka Kotahi recognises the difficulty in achieving sign separation compliance in low speed environments. And so I've reviewed my recommendation, and I'll now be recommending to you that sign S9 is amended so that it relates to all zones other than the commercial and mixed use zones.
So would that leave
Any
no
discussion
separation? That would leave no separation distance requirement, Ms. Gibson?
That's correct.
In those zones.
That's correct. Within those zones only, yes.
Okay, thank you for that.
All right. Shall I move on to the next matter? Rightio. And that's the permitted maximum height for freestanding signs. And the plan reference here is effects standard sign S7. Now, in my section 42A report, I recommend an increase in freestanding sign height from 4 metres to 5 metres in the commercial, mixed use and general industrial zones. And Mr. Brophy for Blue Haven seeks that the maximum permitted height is increased to 8 metres. Now, an 8 metre high sign would be, just to give some context, almost as tall as a 3-storied building, which are typically around 9 metres. And in my view, this is excessive for a permitted activity standard. Mr. Brophy gave the example of a fuel station sign, which I do accept are commonly seen and anticipated throughout the country. However, I think the general acceptance of these signs is anomalous, and that 8 metre high freestanding signs on all sites within those zones would neither be accepted nor anticipated. And so I stand by my recommendation and my position that resource consent pathway is the most appropriate for freestanding signage greater than 5 metres in height. Okay.
I'm just really asking for your planning reasons for that. Is that amenity related? Must be. So just explain that a bit more.
Yes, I think probably of all sign types, freestanding signs have a significant impact on amenity. They also represent a driver distraction by their sheer size and the fact that they are separated from the building, so they create another structure in the visual environment. I think you've probably picked up on my section 42A report that I'm more pro signage on the side of a building, on the front facade of a building, rather than freestanding signs, and allowing a proliferation of those.
So is that from an urban design aspect or amenity, or like we also heard quite a lot from the submitters about this was quite a subjective matter?
It is subjective, isn't it? And it requires a deal of judgment. I've looked at what other councils have done around the country. There's not a lot of consistency, but for example, in Wellington, the centres and central business areas have a maximum height of 6 metres. In Dunedin, it's 8 metres, that's industrial zone though. Best practice is very difficult to determine. There are so many approaches across district plans. And I guess, it's the same conversation as we're having here and with the submitters as well. But on balance, for a district our size, what I've recommended is what I consider appropriate, taking into account those approaches, the benefits of simplicity and the particular resource management issues we're facing, which have been, numerous freestanding signs across all zones.
Kit, do you have a question on this one?
Oh, look, I mean, I'm just trying to think of the reasons for and against, and I mean, to some extent, it's a bit. I find it to say that this is an amenity reason to avoid visual clutter or driver distraction sort of misses the point, because the whole point of a sign is to distract a driver. And I'm just sort of looking at the contrary proposition where the sign is too small and drivers end up slowing down, looking for where they're going to go, and by definition causing a traffic safety issue as they sort of curb crawl, waiting to find out where they have to go in to see the business they want to visit. So to some extent, a large sign that's clearly visible actually assists in minimizing traffic disruption from experience. But I think you're right. It's very much a sort of a district specific issue. It comes down to the way in which roads have been developed, what the setbacks of buildings are, how closely held the sites are, the nature of the buildings, the existing height of the buildings, to sort of all get that balance and sense. So look, I don't have any other sort of proposition either way. I take it though, what you're really talking about here is what's the minimum you would accept for a permitted activity standard. You're not saying that a sign of 8 meters might not be appropriate, but it would have to be specifically thought through in the context of a development proposition, which may actually include a whole of site development proposal where you can see that the signage at that height is actually going to be okay.
Yes, yeah, that's correct. And I think what we mustn't lose sight of is the fact that this chapter is quite enabling, that where the permitted standard can't be met, there's a default to the restricted discretionary process. So, it's not as if these signs are going to be prohibited if they're 6 meters high. So I just think that's worth bearing in mind as well.
Yep. Okay. I had no other questions then. Thank you.
Thank you. Right. So thirdly, the use of the term architectural features, and this is in the rule relating to signs attached to buildings, which is rule sign R6, and specifically clause 2, which requires that signs are displayed on plain wall surfaces and do not cover or partially cover architectural features. So in its submission, Blue Haven sought that the word notable preface the term architectural features, which I didn't support for reasons outlined in my section 42A report. In his brief of evidence, Mr. Brophy now seeks that the entire clause be deleted on the basis that the term architectural features does not provide enough certainty. And I agree with Mr. Brophy that permitted activity rules need to be clear and easily understood, and I don't dispute the established line of authority in case law that the council cannot reserve itself a discretion as to whether an activity is permitted or not. However, I don't agree that the clause should be deleted. I consider it's really important that any proposed signage on a building should involve an assessment of whether the sign obscures any architectural features. And unlike Mr. Brophy, I consider the term to contain enough measure of certainty to be useful, and that it shouldn't be deleted simply because it requires an exercise of judgment. And Mr. Brophy referred to case law in his written and verbal evidence, and I'll attach that to my written right of reply. But I've read the case, and while interpretation issues associated with the term architectural features were raised, ultimately the court had no issue with it. And I also note, and it was a 2002 case, and I note since then in a number of second generation plans that the term has been used commonly. Auckland's signage bylaw, the Dunedin District Plan, the Christchurch District Plan, and Wellington District Plan all use the term, most without defining it. So are there any questions on that at the moment? I realise you haven't had the case to look at.
Not for me, but
sorry.
Yeah.
The term is not just used in R6 though, is it? It's used in R5,
it's R5
as well.
Yes, you pointed that out during the hearing, didn't you?
R5 and R6.
Yes.
And yeah, architectural feature. What do you? I guess this is where his notion of putting the notable in there was trying to qualify it, because every architect would say that every aspect of their building is an architectural feature. So, you know, where do you sort of draw the line? I mean, I'd initially thought you were mostly interested in sort of heritage features of buildings to some extent, but the fact that you've used it both in the signs on heritage buildings and signs on non-heritage buildings, it's got to be something about, there's things you don't want to be covered up, don't you? I mean, that's really what you're getting at. Yeah.
Yes, and it's the result of poorly placed signs that have extended across windows, above parapets, or, you know, obscuring cornices. I'm running out of architectural terms here, but it's not a technical term. It's it is a non-technical term with an ordinary meaning. One option would be to include a definition in the plan. I think one of those councils does.
Let's get a bunch of architects. Let's get a bunch of architects together to do it, shall we?
to list their favourite parts of a building.
That's right. Is there any reason why in the rule R5 you're not allowed to have signs that cover or partially cover windows or architectural features, but there's no similar mention of windows in R6, or is that just a drafting oversight?
It's not something I've contemplated, and is possibly.
So for non-heritage buildings, it's quite happy to put signs over windows, but just not over architectural features. Must be a drafting mistake.
Oh, sorry. The sign. Are you looking at sign R5?
Sign R5(2).
Yes.
And versus sign R6(2). Oh, I see. No, sorry, I'm worked out. So R6(1) brings in a reference to windows at the ground floor. So it's dealt with separately there. Okay, now that makes sense.
Correct, right. Yeah, that's right. Okay. Yes.
All right.
Yes, I think perhaps in its the simplest explanation is that looking at a building, what the rules are prepared to sacrifice are the plain wall elements of those buildings and establishing signage there, and leaving the remaining features and windows perhaps as unimpeded by any signs.
So
remembering again, this is a permitted standard.
Yeah. So you're looking to ensure that the drab walls get the signage, but the fancy walls don't.
Well, the fancy bits of the walls don't.
The fancy bits of the walls. All right. Well, there's your definition.
Yeah, that's right. Yeah.
Signs shall not cover fancy bits of buildings. There we go. I'm sure the architects. All right. Enough of that. I'll let you
in my section 40. Sorry, in my section 42A report, I do pop in a potential definition if you were of a mind to go down that line.
Where was that again? Remind me.
It's in my section 42A report. Signs on buildings. Sorry, let me find the. It's at paragraph 157.
Yes.
Does that come from
Okay.
another plan, Ali?
It has been lifted from. I'm sorry, I can't remember which plan, but yes.
Okay.
Okay.
And
I
perhaps
know
modified.
working with some architects, they would contend that the cladding they use is part of their architectural feature, and for some buildings, particularly modern buildings, it's the cladding that does define them rather than the old style of balconies, cornices, parapets, those sorts of things. So yeah, it's
Yes.
yes.
This piece of case law that I'll send through to you canvassed that very issue actually, and they were talking about some coverings over a car parking building and whether they constituted architectural features. Yes, and there was some debate with architects, and that you'll be interested to read that, I'm sure, in the context of this debate.
But thank you for just suggesting that alternative, which I do note, having read now 157. Thank you.
Great. So moving on to signs on buildings. 3 of the 5 submitters that we heard from requested that the provisions for signs be more generous where they relate to the commercial and mixed-use zones. And the key issue that was raised relates to signs on buildings. So looking first at the sign face area standard, which is sign S11, I've recommended in my section 42A report a 15% front facade coverage in the centres and mixed use zones and 20% in the large format retail and general industrial zones. And that's up variously from 5 and 10% in the proposed plan. Mr. Brophy and Mr. Ekdahl both would like to see that increased to 40% across a number of commercial and industrial zones. They both stress the importance of signage and its support for businesses in the commercial zones, and I recognise that this is a key strand of the objective for signs. And I support a further but moderate increase in the permitted sign face area for signs on buildings. I recommend increasing the permitted coverage from 15% to 20% in the commercial and mixed use zones, bringing it in line with the large format retail and industrial zone, thereby simplifying the standard. Once again, looking at other plans, a 20% permitted sign face area for buildings is not inconsistent with the second generation plans. The Auckland Council standard for centres and mixed use zones, signs on walls are restricted to cumulatively not covering more than 25% of the street frontage. So that's where I've come to in my thinking around this matter, but I'd be interested in your discussion or questions.
Thank you for that. I'm just looking at those standards, and just is it clear that when we talk about the area of the building facade, how does this apply to a building that might be a corner site? Is it of each facade, or because of course, you know, in standard 11 substandard 3 for some of the other zones, you've got maximum sign area 3
Correct.
square meters with no reference to facade, but just a maximum of 1 sign per site for each road frontage. So
Yes.
so how, I mean, the building facade measure, is that something which everyone understands?
Well, potentially not, because Mr. Ekdahl raised that very issue and queried it. What is the facade? I think, I'm not sure that he talked to it, but it's in his evidence. Sorry, I'm just looking at the rule itself to see if there's a reference there to
it's
which is sign R6.
Yeah.
No, which doesn't talk about corner sites. Yes. Yeah, so that's perhaps something that hasn't been contemplated. I'll need to have a thorough look at that and respond in my written reply.
All right, if you could, that'd be good. I mean, it's not as if it's opening a floodgates to some extent, is it? If a site presents 2 frontages to the street, then it's got 2 facades. But anyway, maybe just have a think about that, because that might be an issue. All right. But apart from that, you mentioned the Auckland rule, which talks about cumulative area. Is that sort of concept incorporated within your standards? I think it is, isn't it? Maximum signage area. So it's got to be, so you could, within that, if you've got a 50 square metre facade and you're allowed 20% of it, so that's 10 square metres of permitted sign area. If it's got 5 tenants in there, then you allocate them 2 square metres each effectively. Yeah. Okay.
Yes, correct. The Auckland example, I think it has a square metre maximum as well for each sign. Okay. But I've tried to keep things as simple as possible.
Yep. Okay. Yep. All right. Thank you. That's helpful.
Right. So moving on now to veranda signs, and the plan references here are rule sign R7 and standard sign S12. Now, while talking through the photos in his speaker notes, Mr. Ekdahl expressed displeasure at the restrictive permitted veranda signage provisions. What the plan allows for is signs under the veranda and signs on the veranda fascia. It doesn't permit signs on top of a veranda. It's an approach that I agree with, and I've set that out in my reasons in paragraph 258 of my report. But in short, it's that signs on top of a veranda don't visually integrate with the building. And in my mind, Mr. Ekdahl's visuals sort of demonstrated that, particularly the one in Fitzroy. I'm of a mind that permitted signage should reflect the form of the building. But where I think there is scope to accommodate Mr. Ekdahl's concerns is increasing the sign size on the veranda fascia. So at the moment, the plan requires that the sign is within the fascia, and I think there's scope to allow for the sign to project beyond that in a profile that mimics the shape of the fascia. So I think that I haven't drafted up a clause, but the simplest way would be to something along the lines of the sign must have a maximum projection from the veranda fascia of, for example, 30 centimetres, something like that. So those are my comments on the veranda issues.
That would be 30 centimetres up and down, perhaps, or you'll craft something for us to look at.
Yes.
Yeah.
That's correct. Yes. Yeah. All right. Shall I turn our attention now to signs on heritage buildings? And this was largely Mr. Allerton's submission here. So the proposed plan allows as a permitted activity one sign of no more than 1 square metre on the front facade of a heritage building. And this is very limiting, particularly when there are multiple tenants in a building. Mr. Allerton's requesting that the standard, which is sign S4, be amended to allow for 1 sign per tenant. And in practice, this would mean 6 signs of 1 metre square could be displayed on his building at 42 Egmont Street. Now, in determining the signage provisions on heritage buildings, you would have read in my Section 42A report that I've leant heavily on the RMA Section 6 requirement to protect historic heritage, and also on common practice throughout the country. I did grapple with this at the time, and I admit to having somewhat competing views. Like Mr. Allerton, I think it's essential that a business can display its location. But I also note that the requirement to ensure that the heritage values of a building are not compromised by numerous signs and poorly placed signs. A per tenant rule wouldn't satisfy the latter, in my view. For example, Mr. Ekdal has 15 tenants in 1 heritage building, and that's a lot of signs. So I've given the matter considerable thought, and an option that I'm considering recommending to you is introducing a controlled activity rule for an element of signage on heritage buildings. And my thinking at the moment is something along the lines of 10% of the building facade below the veranda height, or the equivalent where there is no veranda. This ground level story is typically already quite modified, especially where heritage buildings are used for commercial purposes. I think this would increase the opportunity for multi-tenancy situations, while ensuring that the council still reserves control over limited matters such as the placement of the sign and perhaps the colour. I don't know, I haven't thought quite that far ahead. I realise this is probably not ideal solution for Mr. Allerton, in that it would still require a resource consent and associated costs, but it would have a guarantee of approval. So that's where I'm thinking at the moment on that matter. Have you got some questions or discussion on that?
Oh,
No?
for me anyway,
Okay.
I quite can think controlled activity rules in that type of situation can be very effective. And you know, working with developers and building owners myself, I know that, you know, controlled activity approaches certainly don't scare them off when there's no right of you know, notification, and perhaps there's a negotiation that can go on with the council. So I think we encourage you to continue that thinking and see what you can deliver for us.
Great, thank you. Right, so now turning our attention to signage on the side walls of a heritage building. Now, signage on side walls of buildings requires resource consent, regardless of whether the building is heritage listed or not. So Mr. Allerton's requesting that FX standard sign 11 be amended to allow signage on 50% of a side wall or 50 square metres, whichever is the lesser. And so he seeks that standard relate to both heritage and non-heritage buildings. And I also note that Mr. Ekdal would like to see a permitted element of sidewall signage on all buildings as well. Now, the plan's intent here is simple, in that including no permitted activity sidewall signage provides some relief from sign saturation. And in my view, it's an effective approach to supporting priority signage, being wayfinding signage and business location signs, as well as contributing to road user safety. I think one thing that Mr. Ekdal's images show is that there's a lot of signage in New Plymouth. I'm told by the planning team that it's something that people comment on, sometimes negatively, sometimes positively. That's a matter of opinion. But the general agreement, at least anecdotally, is that there is a lot of signage in New Plymouth. You'll have your own views on this. And if the panel was of a mind to allow an element of sidewall signage, I would really recommend restricting this to perhaps the city and town centre zones, but looking perhaps even at a higher restriction or a greater restriction than that, given that the one-way system is affected by the city centre zone, just one side of one road of the one-way. And this is an area really, if you've read the Section 32 report, where we've really had an issue with a lot of signage on front facade, signage on sidewalls, freestanding signs, and it is a high traffic area. So I just want to point that out to you if you were of a mind to allow some sidewall signage. I think that's all I had to comment on the sidewall signs. If you have any questions?
What was your reaction to the questions I had of Mr. Ellerton about looking at his sidewall and pretty much half the sidewall covered in a sign? You know, his 50 square meters or half. That's a big sign. Are you
Yes.
suggesting something different to that?
Well, I'm supporting the position of having no sidewall
Okay,
signage.
so you won't be recommending to us. Yes. Okay.
No, unless you would like me to draft an option for you, then I'm happy to do that and include it in my reply.
This is your opinion,
Correct.
so I wouldn't like
Yes.
to direct that you do that. We've got the evidence from Mr. Ellerton, so yes, I don't think it would be appropriate for us to direct you to do that unless you thought it was really an option that you could support.
Right. Thank you. Okay, so one last matter that I would like to comment on is construction hoardings, and the reference in the appendix of Mr. Brophy's evidence in chief, which seeks that construction hoardings be permitted. I would just like to draw your attention to the rule for temporary signs, which is rule R3, and just point out that that rule at clause 3 allows for construction signs. They are subject to timeframe parameters and the same standards as other temporary signs. But what I'm just wanting to flag is that there is an element of permitted activity signage for construction signs. My principal concern with hoardings is their sheer size and consistency with the scale of other temporary signage. And I think that there's some assessment rigor required, particularly around road safety in those situations. Yes.
Just on, am I unmute? Yeah. Just on that, I see, for construction sites, yes, it's permitted, and you've got to meet the sign effect standards. What would be your controls then? I mean, let's assume you've got a building site on Devon Street that's, let's say it's got a 10-metre frontage, and the building gets demolished, and there's a 10-metre by, let's say, 2.5 or 3-metre hoarding that goes up adjacent to the footpath to keep the site secure. So you've got 30 square metres of hoarding space. What would be the maximum amount of construction signage that you would be allowed under the standards then?
I think the standard has a 5 square metre permitted.
Okay.
Let me just
yeah.
check. I just want to check that. Sorry. Oh, it's one of the early ones. S2, I think.
That's it. So so in that scenario, it's a temporary sign,
It's a
and
temporary
you're
sign, correct?
allowed one, and it has to be 5 square meters, and maximum height
Yes.
from ground level 4 meters. Okay, so
Yes. Yes.
5 square meters. I guess it only becomes quite limiting if you've got a really, really big frontage with quite an extensive hoarding. Isn't that right? Yeah.
Yes, that's right. And you'd have it would look like a postage stamp, wouldn't it? So,
Yeah,
but I
that's
guess
right.
the purpose of hoardings isn't for,
Yeah.
to display signage. The purpose of hoardings is for health and safety
Well, yeah,
of
that's
the
right. And yeah,
pedestrians.
in a lot of situations, seeing around the CRL construction sites in Auckland, the hoardings are massive because there's just so many streets shut off. And what Auckland Transport have done is so the sites carry health and safety information. They also carry really quite, interactive visual imagery of what the finished stations and everything are going to look like, just so that you're not presented with a blank, panel board face in quite a high pedestrian area. So they sort of do it to preserve the amenity and visual interest of the site and interact with pedestrians. I mean, would you consider that sort of approach as still being considered temporary signage under these rules?
It would be considered temporary signage, correct? I think, though, if a developer is at a point where they've created visuals for their construction, perhaps they've already received consent and the construction hoarding signage could be part of that.
Yeah, that's right. So what you're suggesting is that if a developer wants to manage their hoardings with more visual interest than what the signs provide for, they'd actually seek that as part of their resource consent. I think you're probably right. Yeah. And at that point, the council would have the ability to place a control on content and what can actually be displayed and all of that, so it doesn't get taken away by third-party opportunity and stuff like that.
Yes, that's right. And also for the roading team to have a look at it and make sure it wasn't going to cause any road user safety issues.
Okay. All right. Thank you, Mr. Chair. Thank you, Ali.
Thank you.
Yes, Ali, thank you very much. And we look forward to your written right of reply. Thank you.
Super. Thank you.
Now, team, it's 3:30 and we've been going for 2.5 hours. I feel we should just have a quick break before we talk about Earthworks. So let's make it back at 3:35. So it'll give us a few minutes just to have a break so 3:35, is that all right? We've got a bit to get through, I think. Thank you. Welcome back, everybody. Just checking that Commissioner McMahon has got through to us. Is he there? Hey, David. And we're moving on to the Earthworks topic. I think I'll just wait until we see Kit come up back online as well. Here he is. Hello, Nicola. Welcome back.
Afternoon, thank you, and thank you for the break. It meant I was able to go and deal with a piano lesson that required my computer in another half an hour or so. So much appreciated.
It's all good.
Good afternoon, commissioners and everyone else that's sitting in today. I'm Nicola Lawrenson. I'm the author of the 42A report for Earthworks. I've structured this reply primarily by provision to deal with the matters that are outstanding from the hearing. However, taking this approach it means I haven't considered the concerns of each submitter as a tidy package, so you'll have to bear with me because they're not always grouped together. I am happy to take questions as we go or at the end, noting that there is a bit to cover off. And we've run over time already, I think. So just starting with our Earthworks policies. There are still a few outstanding matters relating to these policies, notwithstanding they were generally well received, I thought. I will talk to EWP4 a little bit further on, but just first I have a couple of comments about EWP1, P3 and EWP7. So policy EWP3 is an assessment policy, an assessment consideration policy, by virtue of the fact that it requires something to be done by an applicant to achieve the Earthworks objective. The things to be done in this policy, however, are already addressed in large by the rules and standards which set out the thresholds for earthworks and land disturbance. In this regard, I can understand the concerns of the submitters that anything proposed that is greater than the parameters of the rules and standards may be viewed unfavourably in the consent process. The relief sought on this matter ranged from the deletion of the policy from PowerCo to amending parts of it from Greymouth Petroleum and the oil companies who helpfully provided two alternatives, and Kāinga Ora, whose focus is on cut depth and fill height in this policy. To this end, I would like to further consider the role of this policy and undertake some analysis because changes may result in a policy approach that differs from other district-wide policies. So I would like to address this further in the written right of reply. We had some amendments requested for EWP1 and EWP7. So in EWP1, a quantifier is sought for the inclusion of rule EW R12 to support the recommended changes to the policy. This would round out what is allowed as a permitted activity in terms of earthworks. I consider that this request has merit and makes sense, as a revised policy that includes this quantifier sends a message that earthworks for other activities is appropriate where the volumes of such earthworks are low and standards are met. We also heard from submitters seeking amendments to change the words avoid or minimise to avoid, remedy and mitigate, and use the phrase to the extent practicable. I understand that Greymouth Petroleum and the oil companies prefer the avoid, remedy and mitigate wording as it aligns with the Act and in their view does not introduce another layer of expectation in the consenting process. Noting that the notified wording provides greater clarity than avoid, remedy and mitigate, which are more general terms, these terms are used widely across the plan, and I'd like to undertake some more analysis into this. Next, I want to move on to EWP4, but do you have any questions so far? I don't know if you want to ask as we go or wait till the end.
Nicola, I did have one question about EWP3 and EWP5. and potential overlaps with those. Do you see them as being appropriately distinct to need them both? Like I think one of the submitters thought P5 could stay because it covers many of the matters in P3.
Yeah, I take the point that they have made, and there is some overlap. And that's why for EWP3, I just want to have a look at why that was included like that. Like, was it meant to inform our rules and effect standards? Is it a manage policy, or is it actually a requiring policy? So I do want to just have another read of the Section 32 report and work through that, given that I wasn't the author for this chapter originally. Because
when I matched up the matters in P3 to P5, there seemed to be direct correlations with each item.
Yes.
So yes, if you could have a look at that on the way through, that would be really appreciated. Thank you.
No worries. So just moving on to EWP4, EWS5 and matters of discretion. So Ms. Mako and Ms. Hokopaura both discuss the impact of earthworks on unmapped, unscheduled sites, stating that earthworks are the most destructive activity to SASM or sites and areas of significance to Maori and historic heritage. We heard that SASM are SASM regardless of whether or not they are scheduled in the district plan, and we also heard that unscheduled sites are vulnerable. We also heard that scheduling is a tool for protection, but that we have an incomplete archaeological record and not all SASM are mapped. There was also discussion around the creation of the schedule and the burden of providing evidence, and as a result, there are known sites to Maori that are not included in the schedule. At the other end of the spectrum, we heard evidence and submissions from Federated Farmers, Transpower, and others that, while sympathetic to this issue, consider that the district plan should provide certainty for landowners, network utility operators, and the like. I acknowledge that there is a strong relationship between the sites and areas of significance to Maori and historic heritage chapters and the earthworks chapter. Specific rules relating to earthworks and land disturbance where on or near scheduled sites or areas are located in that chapter and the historic heritage chapters. Those chapters seek to specifically address the values associated with sites. As we know, we have an incomplete archaeological record. Therefore, the potential impact of allowing general earthworks is that unscheduled sites may be discovered or rediscovered as a result of these earthworks. We heard through the course of the hearing that there was a preference from iwi and hapu for adaptive management through a resource consent process to resolve issues that arise through the course of general earthworks and to ensure that SASM are protected. Having listened to all of the speakers, I asked myself if the earthworks chapters should provide for unscheduled sites, or should the issue be left to other chapters of the plan, or should we be taking an approach that only scheduled sites are provided for? This brings me to the discussion around EWP4. So we heard that the policy direction undermines and conflicts with policy in the SASM chapter. We also heard that the drafting undermines the strategic objectives because it provides a pathway by which unscheduled SASM are able to be destroyed without an earthworks consent. Conversely, we heard that EWP4 should be retained as it specifically deals with the effects of earthworks on sites in areas of significance to Maori, historic heritage and archaeological sites. There are similar policies in the historic heritage and SASM chapters, but it can be viewed that these afford protection and manage effects without specific reference to general earthworks and do not address the impact of earthworks on sites. We heard from speakers on behalf of iwi and Federated Farmers that EWP4 could be deleted and that this would allow policy SASM P5 and others to prevail. Ms. Walker also raised the issue that EWP4 appeared to be out of step with the remaining policies of the earthworks chapter. Ms. Rapp for Transpower also sought the deletion of policy EWP4, as well as the matters of discretion relating to SASM in the rules for network utilities. Oh, look, my piano reminder's just come up, sorry. Ms. Ratt considers that certainty should be provided in the plan and that the SASM chapter should provide a framework for the SASM and that additional protection should not be needed in the Earthworks chapter. Ms. Ratt spoke about her experiences with the Waikato District Plan. And I just want to have a little bit of a segue at the moment because I've processed a lot of consents under the Waikato District Plan myself, and I have a bit of a different view as a processing planner. So if you just bear with me. I've processed many consents under the operative Waikato District Plan over the last 9 years, and also a couple of consents involving sites and areas of significance rules with legal effect under the proposed district plan, which was notified in July 2018. I understand the point that Ms. Ratt is making that the general earthworks rule of this plan do not have matters of discretion relating to sites of significance. And I understand that she considers this provides certainty, and to some extent it does. Notwithstanding, and in my experience at the council, as a consents processing planner with the operative district plan, where an applicant is going through a resource consent process, usually for earthworks or subdivision, information relating to sites, scheduled or not, is being sought from iwi and hapu on a case-by-case basis to inform notification decisions. That is, the certainty intended to be provided in the rules is not satisfying the minds of the processing planners and decision makers regarding such matters, and there's little guidance in this space. An example of an application that sticks in my mind is a case in the last year where a general earthworks consent at Waikato District Council was cancelled due to the impact the work would have on a site and potential effects of the development on tangata whenua. And you may be familiar, it was in lockdown last year, I think. This issue came to light after the consent was granted. I understand the proposed Waikato District Plan takes the approach that Ms. Ratt describes, where scheduled sites are in and other sites are out. This provides a pathway for scheduled sites, but in my mind will lead to the same consenting surprises such as consultation requests in a consent process going forward. It is for this reason that I support the approach taken in this district plan to ensure that SASM and other sites are acknowledged in the general earthworks chapter policy and rules, so that where appropriate, the matters can be addressed in a resource consent process and the issue is forefront in the minds of the applicants and decision makers when working with the earthworks chapter itself. After reading the pre-circulated evidence prior to lockdown, I met with the author of the sites and areas of significance to Maori chapter and with Ms. Edwards specifically to discuss how we provide for the issues raised about the relationship between SASM and earthworks chapter to align this policy direction. Any revision of this policy should be aligned with the SASM and historic heritage chapters and not conflict with the strategic objectives. Noting that SASM and historic heritage chapters will be heard at a later date, this is something that we wish to continue working on leading into those future hearings. In the meantime, however, consider that the role of EWP4 provides for earthworks specifically for scheduled and unscheduled sites. I also consider the location of the policy in the EW chapter provides a flag to plan users in the most likely place they will look for guidance on earthworks. Finally, on this matter, regarding the exclusion of historic heritage from the matters of discretion, and this was raised by Heritage New Zealand, this was not intentional and not an intentional move to dismiss historic heritage in this chapter, and I consider this can be reinstated in the matters. I'll try and be brief just to talk about accidental discovery protocol. So we heard a lot of different.
Ask one question about EWP4.
Yes.
You would have heard quite a lot of discussion about potential opportunities to alter some of the provisions or add to them or subtract for them. Are you pretty clear that as it stands, it's doing its job?
Before the hearing and when we were allowed in the office, when we met, we had looked at that and we did think that some redrafting was required.
Okay. So you would look at that in your written right or reply, given that if there's an issue there, that's the opportunity to do that.
Absolutely. Noting that as this issue is fleshed out further in the hearings, that actually it might change again.
Yes, so that's where I think consequential changes or deferments or however it's captured. I think Sarah's keeping a running list of crossover matters and things. So we certainly won't forget about this one because it's had so much airtime.
It certainly has. So I'll just round out this with a couple of comments about accidental discovery protocol.
Thank you.
So we heard a lot of different views about this over the last week. My list isn't exhaustive. However, the highlights for me were ADP is the safety net. It allows for prosecution, at which point it might be too late. The purpose of ADP is to provide for participation and management of sites that are discovered or rediscovered. ADP is not the most efficient tool. It has led to the destruction of SESM. It does not provide for the input or different protocols of iwi and hapu. It leaves decision-making to council. In the event it is required, it would not trigger a resource consent process. Therefore, adaptive management isn't provided for. In the event of an ADP process, an authority may be required or obtained. An authority does not necessarily meet the needs of tangata whenua in the way that a consent process might. I consider the retention of ADP in the current or in a revised form to be important, particularly to provide certainty to landowners undertaking earthworks, councils, tangata whenua and other agencies. I consider the earthworks chapter is the most appropriate location for the standard, given it is earthworks near or unscheduled sites that would likely adopt the standard. I've heard suggestions to wording that may allow for greater protection and how this needs to be balanced with providing clear direction to plan users so that the standard is not open to interpretation. So I'll work on that for my right of reply as well. So I have taken notes throughout the hearing about potential changes and noting that there is track changes in some of the evidence as well.
Thank you.
Just turning my mind now to the other submissions we heard on rules and standards. So I'll just start with Horticulture New Zealand. So the outstanding matters for Horticulture New Zealand, I thought were relatively discreet. They were the inclusion of a permitted provision and definition for rural ancillary earthworks and biosecurity provisions. The inclusion of the definition and rule would widen the net of EWR 11 and allow for more business as usual activities associated with agriculture and horticulture. Under the current rules, these would fall to EWR 12, which is our catch-all rule, and therefore it was noted that there would be an added parameter to meet, being the 1,000 cube of volume requirement. My initial thoughts on this are that we could reword EWR 11 to be able to capture these other business as usual activities specifically. Alternatively, EWR 12 could also be amended to allow greater volume every 12 months, or allow the volume earthworks to be undertaken for each activity that requires earthworks. Now, hopefully that makes sense. I can explain what I mean if need be. I have seen this approach in other plans, and I think it was the Waipa plan. Likewise with biosecurity provisions, I had seen an example of this as a standalone rule in another district plan. But I also think that EWR 12 could be amended to provide for this activity. Similarly, we heard about potential new rules for oil and gas activities from Greymouth Petroleum. So the PDP energy chapter allows as a permitted activity petroleum prospecting in all zones and seismic survey in the rural production and major facility zones, with the seismic survey being subject to an effect standard. Furthermore, petroleum exploration and petroleum production activities are permitted only in the major facility zone, and these activities are discretionary activities in the rural production zone. Based on my understanding around the definition of petroleum prospecting, if earthworks take place for this activity, then earthworks would be limited to samples being taken by hand or handheld methods and would likely be a permitted activity under EWR12. Based on the notified rules for oil and gas activities in the energy chapter, I accept that where there is a permitted activity rule allowing an oil and gas activity, then there is merit in considering a corresponding permitted activity rule for earthworks. Such a rule would address whether or not it is appropriate to consider standard EWS2. This is my preference over including a note in EWS2 to disqualify the standards from oil and gas activities generally. At this stage, I consider such a rule would be limited to the major facility zone, but I wish to consider this further and discuss with the author of the energy chapter. Based on all the evidence and speakers heard over the course of the hearing and comments I've already made above, I think that there is potentially merit in either lifting the recommended permitted activity volume for EWR12 in the rural production zone, or amending the 12-month parameter to allow for an activity by activity assessment. This approach is an alternative to the inclusion of additional rules for rural production type activities. Regarding the increase of volume, in my assessments of the submissions, I didn't support an approach that raised the volume under EWR12 based on a regional council rule being met or a consent being granted by the regional council. It was my preference that the rules in the district plan be standalone. It was my concern, like that of other submitters, that a regional consenting process would not address the same matters as the district council. The hearing evidence and marked up provisions I have read have now largely removed references to the Taranaki Regional Council processes and simply request the volume of earthworks be raised. Having reread the Section 32 report for the Earthworks chapter, I can see the rationale for the rule, but not why the volume parameters were set as they were. Noting that there had only been 6 complaints regarding earthworks over the last 6 years, and of these complaints, not all of them related to volume of excavation. Therefore, I'd like to take a look at this more, and just taking note from Mr. Wesney, the conversation with Mr. Wesney earlier about the comprehensiveness of the database to inform the Section 32 process wasn't necessarily a true reflection. Notwithstanding, having sat in the office near the monitoring and compliance staff over the past few years, I can confirm that earthworks is something that is regularly responded to. I couldn't comment on the nature of all of the complaints, but I would say there are a range of issues such as silt and sediment control, tracking of material onto roads, accidental discovery, so on.
Nicola, could I ask you about this overlap issue with the TRC earthworks provisions? I know in Hawke's Bay, can't remember which way around it is. One of the councils doesn't deal with earthworks specifically to avoid overlap. I presume that most of the regional council earthworks rules are around waterways and aspects like that rather than other aspects. Is that your understanding?
Yes, that is my understanding. It's the rules sit in the freshwater plan.
Okay, so you're comfortable that there's no sort of double ups that are concerning?
Not insofar as the district council has rules for different reasons.
Yes,
I mean we are concerned with the migration of silt and sediment into waterways, but we have other things that we're looking at as well.
Okay, thank you.
Just a comment about altering the 12-month parameter for EWR12. This would allow for multiple earthworks activities to occur on a site in isolation of each other while adhering to a 1,000 cube limit to remain permitted. Sorry, my piano notes come up again. I'll just delete that. So I hope that makes sense, just that subtlety around that EWR12 and what a change for either parameter means.
Yes, understand that.
Cool. So similar to Greymouth Petroleum, the planner for Blue Haven spoke about amended parameters for the rule EWR12. In his evidence, Mr. Brophy refers to the volume parameter of EWR12 being 250 cube being limiting for his client's activities. This is on the premise that Blue Haven site lands in a commercial zone, noting that this site in question is currently proposed to be general industrial. While in the general industrial zone, EWR12 permits 1,000 cube of earthworks to be undertaken for activities not captured elsewhere in the rules. Mr. Brophy considers that the operative district plan method relating to a permitted volume based on site area over a 12-month period should be retained and used in the commercial and mixed use zones, residential zones, open space and recreation zones, Maripurpose zone and rural lifestyle zones. In Mr. Brophy's appearance at the hearing and subsequent questioning, I noted that his evidence may have been confused on the use of an area or a volume as the rule parameter, but I understand that they seek a volume-based rule. I also note that Mr. Brophy was questioned on the differences between activities provided for in EWR10, building activities, and EWR12, being all other activities. And in this regard, I've got a couple of comments. I recognise that there would need to be quite careful implementation of these rules, where more than one earthworks rule applies to a proposal or activity. For example, site works where a retaining wall is constructed with or without a building consent would potentially be captured under EWR10 for the wall and EWR12 where the rest of the earthworks are not related to the wall. It is intended EWR12 would capture site works before a building activity or building consent process takes place. There is not a separate rule in the earthworks chapter for site work. Standard EWS2 applies in all instances of the use of EWR12. During my assessments, I spoke to Council's building lead and coordinator about this rule specifically. They expressed concern that the proposed blanket volume rule was, in some cases, particularly in urban setting, more permissive than what is currently allowed under the operative district plan. As an example, a landowner with a 500 square metre residential property can undertake 100 cubes of earthworks as a permitted activity currently, and this would increase to 250 cube under the PDP. Therefore, it is viewed by those staff that the earthwork standards, including EWS2, are important to manage the effects of site work in EWR12. So in this regard, I do not consider it needs to be removed from that rule, particularly because of its catch-all nature. EWR10 would capture earthworks associated with building activities. There are two sub-rules that apply depending on whether or not a building consent is required. Standard EWS2 applies in all instances of EWR10 currently. So I understand that Mr. Brophy considers that the standard EWS2 is of a different nature to the remaining standards which manage earthworks. I infer from this that he means that the remaining standards manage the earthworks without limiting the amount of earthworks, the shape, the form of the earthworks. Mr. Brophy considers EWR10 should be exempt from cut height requirements of EWS2. I understood from his evidence that this referred to both cut depth and fill height requirements as he seeks deletion of EWS2 in its entirety, or a clearer exemption be provided for earthworks related to building activities where building consent is required. This matter was also raised by Kāinga Ora, who considered cut depth does not lead to the amenity issues that fill does. Dominance and privacy comes to my mind when I consider that fill height. I refer back to the section 32 report here, where there is included in that report examples of cut and fill retaining that the proposed provisions are seeking to avoid. You don't need to look far to see some of these examples. In Fernbrook in Upper Vogeltown comes to mind, with a near vertical cut that is higher than some of the dwellings is located on rear boundaries of sites. There are similar situations in Glenavon. Upon my discussions with the building consent staff, they were comfortable that EWS1 did not need to apply in instances where a building consent exists, as the building consent process would address this. I intend to speak to them again with a focus on EWS2 relating to cut depth and fill height. And I haven't been able to do that this week yet, sorry. So Commissioner Littlejohn, you raised the use of notes in the standards. In this case, the use of notes to exclude certain activities from the standards. I agree that where possible, this should be avoided. And this was my approach in the consideration of the submissions. There were several submissions seeking exemptions for activities in EWS2. However, where necessary or appropriate, I sought to exclude the relevant earthwork standard from the clauses in the rule rather than providing an exemption note in the standard. This nicely leads me into the issue of the role of EWS2 in the instance where the contour of the ground is reinstated following cut. It is submitted that EWS2 is not needed to manage any long-term adverse effect. This was raised by the oil companies Transpower and Powerco. In the section 42A report, I recommended the removal of the requirement to comply with EWS2 in instances of some land disturbance for the same reasons set out in these submissions. Coming back to the use of notes, and this is something that I want to consider further. So in the case of an exemption to a standard for a specific reason rather than an activity, should this land in the standard rather than having a rule that says you must comply with EWS2 unless you are? I want to consider this a bit further and look across the plan for any similar examples. While still on the topic of Powerco and Transpower, I'll just move on to EWR9, which relates to network utilities. So there were a couple of matters raised here. One regarding the matters of discretion relating to tangata whenua, which I hope I've already addressed for you, and the location of the rule EWR9 in the Earthworks chapter. So I don't think this is the last that we will hear of this matter about where things land in the plan. I take the point of Ms. Ratt and Ms. Anderson that a one-stop shop for network utilities would be tidy for them or for the providers. I'm concerned, however, that duplication would be required to facilitate this move. The move would require a duplication of earthworks effects, and I consider this to be counterproductive to what the plan is trying to achieve, which is grouping like rules that have similar values or effects to be managed in the same place, in this case, earthworks. Notwithstanding, I concur with the evidence of Ms. Anderson on another matter relating to standard EWS3 for site reinstatement. I don't know if you've got that up, but she says that I think we've got 6 months from the commencement of earthworks, and she's suggested that be the completion of earthworks. And regarding the requested change to EWS4, which seeks to include effects on electricity lines, I would like to consider this more because the standard currently deals with waterways and roads. Finally, or last but not least, I suppose, I want to address the evidence of waka kotahi and acknowledge that my approach to consider rule EWR7 with EWR9 was based on both notified rules already sharing a parameter. In hindsight, I should have considered this more closely because upon reading the evidence, I understood and agreed that there is potential for implementation issues with EWR7 due to a zone-based approach. In this regard, different standards for different zones, such as that taken for network utilities, is no longer my preferred approach for this rule. However, I've not yet considered the second part of this submission about what an appropriate rule parameter for volume is, and would like to take the time to consider this. And that brings me to the end of my speaking notes today. So thank you for bearing with me and allowing me to reply to the matters raised. Some tricky. I'm happy to take questions.
Perhaps let Kit start off here.
I actually don't know if there's much I have for you, Nicola. Let me just go through. I thought yeah, the one I did actually want to talk to you about is rule. I might have mentioned it in questioning to Mr. Campbell. Actually, it's the one that makes earthworks associated with a new road a fully discretionary activity. What's that one?
13.
13. Yeah. I mean, I don't. Were you here when I spoke to Mr. Campbell about this?
Yes.
Yeah. I mean, I'll throw it. I mean, I initially read it and thought you were potentially controlling it because you wanted to have you had a concern about where a landowner might actually put the road, rather than with the earthworks per se, and that it might be better located as a standard in subdivision. I mean, do you have a response to that? What's your view?
Having not written the rule, I based my understanding of it from the Section 32 report and from discussions with staff, particularly in the consenting area of development engineers. My take on it is that the motive for the rule was for the reasons that you talk about. It's about where the road is going rather than the management of earthworks, which is also an issue because they do need to be managed. And I guess I don't really have a view on removing it or putting it anywhere else. I'd have to consider that. What I do know is that I understand there was considerable thought put into where it should land, and for whatever reason, this is where it did land.
I appreciate your honesty. Yeah, I couldn't actually. I mean, the reason I sort of started pulling on this thread was from when I read the Section 32 report, and it identified in the rules that were going to be put into the proposed plan this rule around earthworks to create. And I've just gone back to it instantly right there. I've highlighted it and put big question marks and wrote, where did this come from? So it was obviously something that sort of jumped out at me as a little bit discordant within the framework of the Section 32 on earthworks. But look, I appreciate your candor on that. And I mean, it's probably something we can throw around again in the context of the subdivision chapter, I think, because I'm not saying councils ought not to be able to control where land developers put roads, but I just wonder whether there's enough tools in the toolbox already in terms of the requirements of vesting on deposited plans and the need for subdivision consents that they can control that anyway. But look, I'll tease that along in the subdivision hearing, I think.
That's brilliant. That'll be me too.
Oh, excellent. Well, you've got a chance to think about it then.
I do. Thank you very much.
Excellent. All right. Now, that was the only thing I wanted to sort of draw up, Mr. Chair. So, yeah, I appreciate. Yeah, thank you.
Thank you, Kit. And Nicola, thanks for just letting us know the matters that are still at work on. Certainly appreciate that. without access to your colleagues and people we would normally rely on in council, it has been difficult. And look, I followed pretty closely the Earthworks discussions. I certainly have taken a lot out of your summary notes about where the various contests were. And if you've got those written notes there, I think they will really help us in our deliberations. And I think you've got a couple of weeks to write up the right reply. So it seems like there's a fair bit of work for you to do in those in that period.
I thought we had the Earthworks certainly had the lion's share on the last day.
Yes, yes. So yes, thank you very much. I don't have any further questions. And,
Commissioner, sorry, yes. Commissioner Coffin's either giving a high five or he's got a question.
Yeah,
I've got a quick. Sorry, Stephen, you might not have seen me on the big screen with all of the. It was more of a clarification more than anything.
Yes.
Just in the small amount of time which I joined this particular hearing, because Commissioner Dash had a conflict of interest. I heard the submissions of Mr. Holswich on behalf of Ngāti Rahiri, particular to the accidental discovery protocol, and his submission was around some of the workability of those specific standard EWS 5 in regards to its workability on the ground. And I just wondered if you had any reflections, or you'll be just providing some comments in regards to that. He gave a quite a good example where he said, no, in a case of a driveway, or there was a site of significance which might be long rather than in a circular, depending on the shape of the type of site of significance, that can change I suppose the procedures that would be appropriate in the circumstance, and how a standard may be able to anticipate different on the ground situations. So just whether you had any views now or will be including those in your report.
I will include that in my written right of reply. I think that I wish it was straightforward, but it is a tricky issue and tricky to manage, and a one size fits all permitted standard. I mean, while possibly not ideal, it's what we need to be able to look after these sites, and I certainly do want to have a think on it. I mean, I've heard all the issues. My list that I read out before was only half of the points that I'd taken on board. There's a lot there, and I definitely I will be taking a lot of time to think about how we can better word that and better provide for participation.
Yeah, I don't think Mr. Holswich's submission was a removal of any sense, but it was just trying to make it fit to the circumstances that they might find themselves on the ground. But vis-a-vis the district plan as a tool needs to be certain enough and be able to apply. So it's actually meaningful and effective.
That's right, that balance.
Thank you for that hand up, Antoine. Good question. And,
I need to say something this afternoon.
Yeah, yeah. And so just for all of the 42A reporters, your right of reply is really important, obviously. We take a lot of notice of the fact as an expert, subject matter expert, we have done the 42A report, you've listened carefully to all of the submissions and the arguments and the questions. And as per the previous rights of reply, yeah, just, obviously we feel that there's been some good points made, just make those suggested recommendations. Certainly it's easier if you haven't been writing the provisions yourself like Nicola has. You can look at them reasonably dispassionately, but yeah, just we look forward to receiving those replies. All right, we are now to change gear, I think, and talk about matters of discretion. And I just wonder whether, Sarah, you had any preliminary thoughts about how we might do this?
Yes, so I have put together some notes, and perhaps what I could do is start with an introduction on what we've been doing while the hearing has been going on and where we've landed on things. As I stated at the start, though, there were 2 matters, and I'm mindful that we have got some submitters that have been on the whole time, and whether they want to listen to the discussion, of course, those people are most welcome. But there are 2 matters that I did raise at the start. One was about the process for pre-hearing meeting with federated farmers, and then, of course, the matters of discretion discussion. If it's okay, would I be able to deal with the pre-hearing discussion for federated farmers first, just in case those submitters that are interested in that might want to leave the Zoom meeting? Is that okay?
Yes, that's ideal. Thank you.
Okay. So you asked of me whether I could outline a process for a pre-hearing meeting with federated farmers, and certainly we are very welcoming of that, and can reach out to federated farmers and Ms. Walker and work out how that can be done. There's a few things I just wanted to say as well while I've got a captive audience, I should say. We definitely acknowledge and thank Ms. Walker for her statement on behalf of federated farmers. We heard that there were no significantly different perspectives between federated farmers and the planner on the Earthworks chapter. And of course, you've heard from Nicola on those today. But what I was particularly interested in to hear about were her views on the consultation process, particularly her concern that there had been a lack of consultation with landowners on these sites of significance, with landowners that have sites of significance to Māori. She talked about the use of non-regulatory methods and incentives provided by council, and that the members of federated farmers often don't know about these, and that council could do a much better job in prioritising and resourcing those non-regulatory methods. As noted by Ms. Walker, these points are covered in detail in her submission and will be really prominently addressed through the sites of significance to Māori chapter, sites and areas of significance to Māori chapter. So that's where you're going to hear a lot about that. You're also going to hear a lot about the Wahitanga review and an archaeological review that went on there. So you will hear that. But what I have invited Joe Ritchie from the team along today, if you did want to think about that now, or if you want to, you certainly don't have to get into that now, but just to give you some background as to what happened with that review and how we landed in the position we did with notifying the proposed district plan, and also what our processes are for dealing with those submitters that have got these sites on their property. But to sum up, what I wanted to say that we're definitely keen to take up the offer from federated farmers where they have indicated that they would like to be involved in any possible redrafting or any type of pre-hearing meeting. And what I suggest we do is that we'll contact Ms. Walker direct and discuss with her expectations on how she'd like to move forward and how we can get together and talk.
Yes. Well, I think briefly, if Joe did want to talk to us, that would be helpful, because this sort of came right at the end of the hearing, which, yeah, and as I said on when it was on Monday, it's just whether there was around the table between the council, federated farmers and the tangata whenua submitters, items particularly about some of these non-regulatory methods, this information flow, relationship issues at the time between now and hearing those chapters could be put to some use, you know, outside and pre the hearing. But I'm certainly interested in hearing from Joe.
Kia ora koutou. Can you hear me?
Yes.
Good. Hello. I just thought I'd make a few sort of points, and some of this you will have heard in the introduction to the hearings by the iwi liaison team about the Wahitapu Review project. So just in relation to prior consultation with landowners, I'm aware, I've only been at council since November 2018, but I'm aware that there have been several sort of times of consultation with landowners since the beginning of that Wahitapu Review project in 2006 and 7. And as Ms. Walker stated, it has been iwi and hapu led. So it's obviously related to their capacity to be involved at any particular time. So many sites have been in the plan since that time, and they have not altered. But obviously prior to notification of the proposed district plan, we wrote to, affected landowners within an existing site with a potential new site or sites or changes to the extent of a site. There were 1,150 individual letters that we sent out to landowners on these sites. So quite a few letters. This was, in our view, this was the beginning of the Schedule 1 process for the plan, and it advised, those letters advised landowners of the notification and advertisement, where we could, the fact that we were going to hold planner open days and other ways that they could discuss the sites with us. Some farmers did come and see us to discuss their sites, and we are still underway with an ongoing site visit process to some of the sites that have been submitted on in the district plan. It depends a lot on what kind of submission has been put in on those sites, because some submissions have been very good. They've asked for specific, they've made specific comments that the extent is perhaps incorrect, or that they have other evidence that they would prefer, or other things, and we can interact with some things but not others, depending on the nature of the submission in terms of a site visit. So I am still underway with those site visits, and I am yet to, or I am still underway as well with actually discussing some details of the sites with iwi and hapu, because they have submitted that some of the details are not correct in our notification. So we think, and I believe, that the notification and hearings process is part of the overall Schedule 1 RMA process. So those letters and the work that I'm doing to go and see people who've submitted, if it's appropriate, are part of that overall process. And obviously that's why the hearing for SASM sites is in the later part of the hearings process, to give more time to do that, because obviously it's quite a time heavy process. So some of the sites that have been submitted on by the farming community are not new sites. They're not sites that have been newly notified with this plan. They've been in the plan for quite some time. This may be because there's been a change of ownership for some of those areas, but otherwise it may be because they weren't aware of the sites beforehand. I'm just not sure. Ms. Walker talked about the fact that Ngāti Mutunga and Ngāti Rahiri, had done the process to interact with landowners. Other more rural hapu, such as Ngā Mahanga and Puketapu hapu, have also met with a large proportion of the landowners with sites in their rohi. So there's been other work that's taken place in terms of the rural areas. Sites in the urban areas obviously have not had so many site visits, and that is, that has been a issue of resources and time as to why that hasn't happened. And once again, we are doing some of those site visits now, and replying to people who've only just found out that some of these sites are on their property. Probably just a couple more points on that I could make. Aside from Ngāti Rahiri's private plan change, all the other iwi and hapu have waited several years for their sites to be amended and for new sites to be added through the RMA process. I acknowledge that that hasn't been ideal from their perspective, you know, that this long 10-year wait between district plan reviews is not ideal either for landowners or for iwi or hapu. So that is something that has been submitted on, especially by Ngāti Mutunga, who've asked that we try and undertake a process that happens more often to update these sites. And I think that would provide more certainty for plan users as well. So we are keen to try and do that in the future.
Right.
Just one other point on the consultation issue, and then I'll take questions if you'd like to give me them. Where there's been a change of landowner, I understand that under Part 2A of the RMA, they become what's called the successor to the submission. And once the successor is advised of the hearing, then they will have the choice to continue on with the submission or not. And this is the case with some sites. One site in particular that I've visited, or that we have visited, the landowner, or we agreed with the landowner that it needed to go on to the adjoining property. It should be removed off his property and put onto an adjoining property. Then obviously that that property owner where the site has been moved to should have the chance to continue with the submission if they want to.
All right.
Yeah, any
anything
questions
else?
on that, on the consultation issue?
Yeah, no, I think we did get a good summary of that when the iwi liaison people at council did do the introduction. And I'm actually quite thankful that Antoine's listening into this, because Antoine, it was a matter, and Antoine and I will be sitting on those particular chapters together.
Yes.
It came about through a submission on the Earthworks rules and some of the matters that relate to sites of significance to Maori and historic areas. And Ms. Walker made quite a, supported by the president of Federated Farmers, quite a plea for some more dialogue, was the way I read it, about some of these sites and some relationship building between their members and tangata whenua and involving the council. So all I really did was note that as we are setting aside these matters until later on in the hearings process, because we do understand there's quite a bit more work to do, whether the council might want to initiate some more formal or informal, whatever, pre-hearing process, just to bring the parties together to have a chat about where those things are up to. Not particularly looking to direct such a process, but just put on the table as whether people thought that it might be an idea. So for me and Antoine, I'll see what you think. Would also need, I think, to get some have some dialogue with the submissions made by the various iwi parties as well, about whether they saw some value in just something a bit more coordinated, and including Federated Farmers, because in my Christchurch plan experience, the Federated Farmers were very influential in submissions down there, and the relationships didn't start happening until after the hearing with many of the people involved. And we had to stop and do some post hearing, pre-hearings, I suppose, for the want of a better matter. So that's just, it's just an open question. We're not going to direct anything particularly. It was just an opportunity to explore, I think.
Yes, I think it's a very good idea, and I'm happy to to try and put that into place with Ms. Edwards and other members of my team, our team.
Commissioner Coffin, did you have any thoughts?
Yeah, just looking at the time, I'll probably try and keep this very brief. It's about 14th of February. It's about mid-February is when we're going to be formally doing the hearing for the sites and areas of significance to Māori, and this seems like a good opportunity because we're already dealing with, in many ways, that chapter already, getting a bit of a heads up of where we're heading towards, what type of form it might take when we're getting into the new year. But certainly opportunities to bring parties together is well supported, I think. Just reflecting on the experience from 2 of the previous plan changes that I was part of. One was to the archaeological provisions, and then one was the Ngāti Rāhiri sites, which were brought into the plan. There'd been a considerable amount of effort done in consultation, and I think Mr. Hoswich, who's also with us, he was one of the instigators of a significant amount of consultation with landowners. I don't think there was a landowner that hadn't been consulted. It was a pretty incredible effort. So it'd be just interesting for you to manage our expectations in terms of what we think the process will have involved. I think at that time there'd even been 2 archaeologists who had been working on resolving tension in terms of issues on the ground in terms of site visits and things like that. So I'm familiar with that process, but it'd be interesting to know how different or similar this process is that you're embarking on.
So I've sort of split it into 3 main areas. There's obviously a discussion to be had with regard to the rules, and that was definitely going to be with iwi hapu and anyone else potentially who had submitted on the rules and how they operate, because it is, having done a couple of site visits with farmers, they are also really concerned, not just, sometimes less concerned with the site itself, but more concerned with how the rules operate in relation to that site. So that's one part of the work we've yet to do. And 2 other sides of it. There's meetings with iwi and hapu to discuss the details of the sites as notified and whether they're correct or not. And sometimes these things can be really simple things like spellings of names and locations, road location details, etc. And other times it could be more specific that, the extent is not quite right, or other more significant issues. And obviously I have only done one of those meetings. I was meant to do another one this previous week, but obviously that didn't take place. And that's done sometimes with archaeologists and sometimes with iwi liaison people with me, to just go through all of the sites that have been scheduled in their rohi to make sure that we have those details correct. And to document them sufficiently for the Section 42A report, which then provides for where there is no agreement or where there is differences, that we can discuss those in the hearing. So that's that side of it. And then obviously the other side of it is to continue on with some site visits with landowners where they have submitted on the plan. And some of them, as I say, there has been, for some of them, these sites have been in the plan for some time. There are reports already on the site, and it hasn't been deemed reasonable to do that site visit. But in many instances, we are trying to do the site visits where people have specifically requested them. You'll know, Mr. Coffin, that these things are very time intensive. I've just spent probably 3 months trying to get one site visit together, which we had just before lockdown. It was an amazing site visit, and there were many parties that came to that site visit. It was a very important site for Ngāti Te Whiti. But that's the kind of time that it takes sometimes to get one site visit operating. If you've got iwi and hapu to be there, you've got iwi liaison people, we've got archaeologists and myself to all come together at the same time, as well as the landowner, or in this case, the leaseholder of sites. So that's the challenging aspect of it, and that's you know, that's not helped by COVID.
No, certainly not. And just the last point, perhaps, is, you know, you'll be aware of Section 42 and protection of sensitive information. Obviously, if you identify there's going to be areas of sensitivity, or the iwi have identified areas of sensitivity regards a site or sites, please let us know through the chair.
Yes, certainly.
We'll provide for that.
And I'm totally guided by iwi as to what evidence they want to provide to the landowners, or to anyone else for that matter, if it's deemed to be sensitive. Yes.
Thank you very much, Ms. Ritchie, and it will be quite good to have more of a discussion about this, but we are running out of time. So we'll just leave it that, Sarah, you and Joe, you'll talk to Hilary Walker from Whero to Farmers, liaise with the iwi submitters, and just you know, get if there is any additional matters.
Yes.
Yeah, we'll just let you carry on and just keep us in the loop. Thank you.
Okay.
Commissioner, just wanted to let you know that Commissioner McMahon has had to leave the meeting.
Okay. It's a bit unfortunate. He's our self-confessed planning geek, so I was pretty keen for him to be involved with this. Oh well, we'll carry on and we'll try and keep him up to speed. Thank you.
Thank you.
So turning now to at the start of the hearing, Commissioner Littlejohn made the following observations about the matters of discretion in the proposed New Plymouth District Plan. So some of the observations were that the matters of discretion were phrased as evaluative, and that other plans have separated out matters of discretion from assessment criteria. But in the New Plymouth context, the New Plymouth plan hasn't. He asked the question, can assessment criteria and the matters of discretion do the same job? Another observation was that the matters of discretion are cast in a way that doesn't immediately enable them to assist the decision maker to determine whether or not consent should be granted, and if so, what the consent conditions may be imposed. He also observed about positive effects, that the matters of discretions really offer positive effects, and is it appropriate to include a general rule? And he referenced the Auckland Unitary Plan, which indicates that positive effects can be considered to relevant aspects of restricted discretionary matters. He also observed that it's not immediately obvious that the effects of non-compliance with the what the effect of non-compliance with the effect standards are, and should an activity status be applied to each standard. And finally, he pointed out some inconsistency that there had been with the cross-referencing in each of the 42A reporting office had used slightly different approach, and that consistency was required. So while the hearing has been going on, we have given these observations some thoughts, and to help with that, we have consulted with our legal counsel, Lauren Willis, and Lauren is here today. She's joined us and she will help assist today's discussion. Lauren can give an overview of the relevant parts of the RMA that she's considered, which are considered to be relevant, as well as some observations on the national planning standards and case law as required. As I outlined on Monday, our first observation is that if changes are warranted, we need to determine whether there is scope to make those amendments. We definitely have received chapter-based submissions that question certain matters of discretions, and if appropriate, are able to make those changes and make them clearer in this regard as we go through the hearing process. But what we don't know at this stage is whether we have a global a global submission that will enable us to consider all restricted discretionary matters of discretion together. So that will take us some time to see if we have scope to look at it at a global perspective, but we definitely know there will be cases, but not all, where those restricted discretionary matters have had, matters of discretion have had submissions against them. Our second observation is
can we just
yes.
Just have a quick chat about that, because I must say I have been thinking about that as well, and it's certainly something. I mean, I don't think we're not contemplating coming to any views at the end of today. We really just want to get council's feedback and then see if it aligns with our own thinking. So let's not. I mean, if we've only got sort of 15 minutes before 5 o'clock, so let's not get too stressed about getting through it. One thing that I'd be interested for your and Ms. Wallace's view on is the scope that is given by clause 10.2b of the first schedule, which very much expands to things such as consequential alterations necessary, or even any other matter relevant to the proposed plan arising from submissions. So there's a very broad sort of net in clause 10. And the other thing I'm interested in hearing views on is it's going back a wee way, but it still stood the test of time, the original foodstuffs decision in 1993, which was upheld on appeal in the High Court, subsequently known as the Countdown decision. And in that case, I went back and had a look at it. Judge Shepherd categorized amendments to wording of a plan not altering meaning or effect as things that didn't offend any rule of scope. And the judge in that case commented that, for example, a submitter, foodstuffs, on that plan change made a whole lot of criticisms about that plan, but the only relief they sought was to request that it be rejected. And the panel originally said, well, we're not going to reject it, but we take on board some of these sort of concerns and we're going to change the wording to make it work a bit better. And that fell within a couple of the four grounds in foodstuffs, but the one around amendments to wording not altering meaning or effect, the judge was quite happy that if you were simply ensuring the language was contemporary with the overriding statute and was correct without actually changing the substance of it, then those were ultimately to the decision maker in the interests of ensuring the plan was effective and efficient and clear. And I guess I want to be very clear that the criticism that I've sort of leveled is not around substance per se, it's more around form. And so that if there was going to be a rethink or a restructure, then it would only be in that form sense rather than in substance, because I think you do need a submission to change the substance of a rule, whereas what we're sort of contemplating or thinking about here is the form of the rule. So I just want you to make sure that you're sort of clear that we're not thinking about a complete rewrite of all the rules to achieve different purposes. It's more around the way in which they're formatted and clear.
No, we had made that distinction, but and we understood that it wasn't about the substance as well, and that's where we, I guess, going back to that point where we have had individual submissions on those particular matters of discretion, that's the place to change that substance. So yes, we absolutely did understand that difference, and when we perhaps can get on to that later on, it's about what we would need to do is if we indeed come to the conclusion that there may be a matter that needs to be looked at, and how we go about that is we'd need to also work out some sort of protocols and the approach that we would take to ensure that we actually didn't affect that substance, that we were only looking at those four matters. So that requires quite a bit of thinking and workshopping, and it's certainly something we can't solve today. But But moving on, what we have observed is that there doesn't appear to be anything in the RMA or the National Planning Standards that actually requires those matters of discretion to be listed separately from their associated assessment criteria. To help us understand the matters further, we've done some research and looked at various plans throughout the country, and what we've found is a bit of a mixed bag. By way of example, Dunedin District Plan has the matters of discretion listed in a column in a table, and the matters include things such as effects on a visual amenity or effects on stability of land and buildings, for example, and guidance on the assessment for each activity which relate to the matter of discretion are then set out in the next column next to it. So you've got a 3-column table that helps with that decision making, and those matters of discretion they help guide the relevant objectives and policies and the potential circumstances that may support the application and the conditions that may be opposed. Now, you also referenced the other day about the Auckland Plan, and we which you're very familiar with, Commissioner Littlejohn, and that they have a separate section for assessment criteria, and that lists the matters of discretion, that those two parts of it are separated out. Hamilton uses the same sort of approach, but what they do is they don't have their matters of their assessment criteria next to the rule. They have that in a separate appendix. So there's different plans that are slicing and dicing things in different ways. What we have found, though, is that the likes of the Invercargill Plan, the Porirua Plan, Whangarei, take a similar approach to what we see in the New Plymouth District Plan, and another plan that, although is only in its draft form, the Timaru Plan, takes that lean approach that we have taken in the proposed plan, where assessment criteria are not set out in any other way, and that it's a combination of both. So in response to the question posed by Commissioner Littlejohn, can assessment criteria and the matters of discretion do the same job? We consider that it is possible, provided that the criteria are drafted in such a way that enables the matter over which discretion is restricted can easily be ascertained. So this issue relates to Commissioner Littlejohn's second observation that some of the matters of discretion in the New Plymouth Plan are cast in a way that doesn't immediately enable them to assist the decision maker to determine whether or not the consent should be granted, and if so, what conditions consent conditions should be imposed. The solution to this would be to examine each restricted discretionary rule throughout the hearings process to check whether they are drafted appropriately, and in the event that they are not, it would be that would be the process that I talked about further with our drafting protocols to work out what is the so what matter that we're trying to cover off, or make sure our drafting deals with the matter. So that's really where we've landed with that. But finally, circling back to the cross-referencing thing, which is really quite a minor matter, and in response to the larger part of the conversation today, is that with the cross-referencing, we can absolutely tidy up some of that consistency wording. I was aware of the use of some reporting planners using bullet points, for example, and how those have come together with that cross-referencing for the strategic direction chapters. So we can certainly tidy that up as part of the writer replies side of things. So we can deal with that. So really now, I guess probably what would be quite useful is bringing Lauren Wallace into discussion, and maybe perhaps just a free flow discussion on some of the points that we've made and some of the observations that we've found as well.
Kia ora koutou.
Kia ora, Lauren.
Hi, how are we all? Cool. It's been a long afternoon to get into this technical stuff. Yeah, I mean, I don't have too much more to add from what Sarah has said. I have had a look at some of the case law around it, so I'm happy to have a chat about some of those, and we've had a look through those other plans as Sarah mentioned. It certainly is treated differently in different plans. So I think one of the points that you made, Commissioner Littlejohn, when you raised the issue was that whether or not they're separated out doesn't appear to be fatal, because obviously that has happened in some plans and it hasn't in others. I think the real issue is whether they have been crafted in a way that sufficiently enables plan users to ascertain what the matter is that the discretion is being restricted to. Yeah.
I think two things, because I'm probably going to, and I know the chair has a few issues there. I mean, the starting point is that the RMA does not contemplate assessment criteria. These are creatures that have evolved to assist participants in restricted, discretionary and controlled activities to understand or apply or consider the matters of discretion. And that I mean, I've not been able to find a case which says you can't have them, and that all of the commentators say that they've just turned up as a matter of convention, really. And ironically, some of the biggest contests that I've been involved in district plan matters are around the wordings of the assessment criteria, because everyone wants a headline in there. Because those are the things that actually determine, in the context of a resource consent, what gets thought about and what doesn't get thought about. And that's probably because in the plans that those things were being debated, the matters of discretion were very lean and objective propositions about the effects that were of concern. And then the assessment criteria actually became the drop-down menu around everything that potentially arose in the context of considering that effect. And so that's where all the contests have been. So that, I guess that's one thing. So there's no law that says you can't have them, but I'm on the same page as you, that if you're going to have them, and particularly if you're going to treat them as your matters for discretion as well, then its clarity has got to be the guiding line. And I'm not sure if you're familiar with the Environment Court's decision in Eden and Thames Coromandel District Council. There's a very useful section in there about the role of restricted discretionary activities, the history of them, and how they ought to be crafted if they're going to be of any use to anyone. And one of the things that struck me in rereading that was the court's observation that if you've got a matter of discretion that is effectively everything, then in fact you don't have a restricted discretionary activity. You've actually got a discretionary activity. And some of the matters in chapters that we haven't got to yet are cast that broad. Any effect of any infringement of the rule is a matter of discretion. I mean, it sort of makes the whole concept of it being restricted a bit ludicrous, really. But I can understand why you want to have things as restricted discretion, because it gives people comfort that there's only a limited range of things that need to be considered on an application, which is all good stuff.
Yeah.
So it sort of circles back to where you started. It's about making sure that the criteria are drafted in a way that actually allows them to do their job.
Yes.
And and so I guess I mean, I'm interested to see whether the chair wanted to throw in some comments there, and perhaps Commissioner Coffin, because it seems to me I don't want to be seen as the lawyer that's being the problem here, even though I probably am.
I guess I would just add that, you know, on an orthodox statutory interpretation, using orthodox interpretation principles, all aspects of a rule need to apply. And so even in the Auckland Unitary Plan, where you have your matters of discretion listed, you then have assessment criteria listed, and you can't say that one doesn't apply or that one has greater weight. So I think that
provision of the plan.
Yeah, and so I think that, or I would submit that the matters of discretion in this plan, some are drafted in the way that the matters of discretion are drafted in a similar way to those that are in the Auckland Unitary Plan, and some are drafted
in another way,
in an evaluative way. And I guess the key is just looking at those evaluative matters and ensuring that they are not so broad that they lose their, you know, the intent of them restricting the consideration. But provided that they aren't, then, you know, I don't consider that there's anything in the RMA or that would prevent the plan from setting them out in that way. And some matters and some assessment criteria.
Yeah, I mean, I don't disagree with you. And some of the chapters follow the very lean approach of just stating the effects that are to be considered, but others have gone into the, you know, whether this or the extent to which that sort of stuff. And I suspect that the reason planners historically in some plans have differentiated between the two was because they wanted these evaluative questions to really frame the approach to the assessment as and be really relevant provisions in the context of the consent, which I think is a really elegant solution. I mean, this plan has sort of bundled them together, and I guess I'm really interested in your view eventually on whether there is anyone we're going to offend if you were to separate them out. And have one column which has your matters of discretion, and then you have your assessment criteria as separate tools that inform the application and use of those matters of discretion. So that, I guess that's where I'm going, because I wouldn't want to see a lot of the very meaningful evaluation that is in some of these criteria lost because you want to lean them down to make sure they satisfy a very strict legal requirement. If you know, I think that would be a retrograde step. You'd be taking stuff out of the plan that's actually probably there for a good reason, because that's the stuff that planners who've written these chapters want to be considered in the context of those rule applications.
Yeah, I mean, I guess my only comment to that would be that a great level of care would need to be taken, because some of the rules are purely evaluative, the matters of discretion, and some do have just those sort of lean matters of discretion. And so with the evaluative ones, you would effectively be trying to pull out from those what the particular matter is and giving it a heading. And then you would need to examine whether or not that does actually, whether that is just a change to form, or whether that does actually bring in a substantive or material change to the meaning or intent of those matters. So I guess, yeah, we just making plans clear is you know, 100% behind that, but I would caution against change for change's sake if these matters are in fact doing what they need to do and are adequate as they are currently framed.
Perhaps, Lauren, I could make a couple of comments here. That Eden versus TCDC case, is that the one that Judge Kirkpatrick issued last year? Kit, is that the?
Yeah, that's the one.
Yeah, and certainly one of the matters he covers quite carefully is that if your matters of discretion are so broad that effectively everything's on the table, that's really not very fair, and they should just be discretionary. And there are some matters of discretion. For example, I was reading one out. it's in the medium density residential zone, whether the adverse effects of the activity can be avoided, remedied or mitigated. So
Right.
as a matter of discretion or an assessment.
Which rule was that?
criteria.
Sorry, Commissioner.
What was that?
Sorry, what rule was that? I'm just going to it now.
It was MRZR3. And there's other similar ones scattered throughout as well. It's 2D.
Oh, yeah.
Yeah. So there's just really careful looking through these about whether, you know, how would an applicant practitioner cope with that in terms of specificity, very wide open. I'd say it was, you know, difficult to look at that as a reserved discretion. It's so broad. So that's just one example about the ones which are so general, they effectively become discretionary because everything's on the table. And there might be some particular background to that. So this, out of that TCDC case, there seems to be a bit of a test around matters of discretion where we are restricting discretion, needing to be focused and clear and not so broad as to introduce everything on the plan. And that's what, you know, that's what really makes great restricted discretionary rules really work, that it's limited, it's crystal clear. But look, there was just one issue. The other issue I've picked up is really around some of the matters of discretion are evaluative in this. They are sort of written like assessment criteria. Some aren't, as we've talked about. But if that single table is dealing with both listing matters of discretion and outlining assessment criteria for applicants, and I think they're doing both, some of them are doing both, some of them are doing more of one than the other, whether you could just actually change the title to include both matters over which discretion is restricted and assessment criteria for applications. And then parties that are used to assessment criteria, because within those there are, you know, many of them are assessment criteria in that classic sense. Certainly don't want to be going meddling around with the form and structure of the plan if some clarity around some of the introductory wordings might help. So that was just another thought I had. And look, this is maybe a little bit off topic, but I'm not crystal clear in terms of the cascade and how this might be used when referring to matters. And I'd like you to have a look at MRZ 11. It's one of these ones that's got the sort of the buff color, and it's RDIS, and there's a list of matters, but then this is in terms of multi-unit developments. And then on the right-hand side, with the activity status where compliance is not achieved becomes discretionary, is a test of not achieved meaning that they don't meet the...
I would say that's an error.
Criteria on the left, because there's no...
Yeah, I would say that the activity status in the second column where compliance is not achieved should be not applicable, given that there are no activity standards to comply with in R11.
Yes. Okay. No, it's these sort of things we're looking at. And while you're there, can you just explain the NA term?
Yeah.
Is that the end of a cascade, or?
That's my understanding, Commissioner.
Yeah.
So, for instance, with MRZR27, the activity status is non-complying, and there's no additional cascade. You don't move any further than that.
Okay. And so, looking across to MRZR33 was one I'd put my ring around. That was
MRZR33.
RDIS.
Yes.
And then that's the bot. You can't go any further down a cascade than that. And that's what NA means. I presume that's, because I look back at the abbreviations in the first part of the plan to try and work there, and it's something that I know Ms. Barry Pacino made some comments on the list of activities that you supplied for Mr. McMahon, Sarah, looking at different statuses of activities. So if that's what that means, I'm now clear that that's the end of the cascade.
Yes, so it means my understanding is that it's not applicable.
Yes.
Because there is no activity status.
Yeah, beyond that.
If compliance is not achieved, because there's nothing to comply with.
Yes.
In the first level of the rule.
All right. Yeah. Okay. Well, those are some of the specific matters. But again, I suppose what I'm perhaps more used to personally, and I know that there's nothing requiring you to do this, is to have the matters of discretion that are a simple statement, and then the assessment criteria, the evaluative terms. And there's a table in the TCDC condition, decision at the end, which sort of sets that out. But
yes.
That would take a big effort, I think, to get to there, and whether the ends justify the means, I've got quite a doubt over.
Yeah, it's a really interesting issue, particularly given that some plans do it and some plans don't. And so I just, I mean, we'd probably need to do a little more work around it to determine what more the headings provide, you know, how the consent processing planners use the headings to offer something else up other than what the assessment criteria that are associated with each heading do. What additional consideration or what additional condition can be imposed where you have a set of specific assessment criteria relating to a particular matter with the heading of the matter enable you to do?
Yes.
Yeah. So we'll have a discussion around that, and yeah, I mean, would it be helpful to the commissioners to have something further on this issue in writing, or?
Well, yeah, I saw Sarah shaking her head there. That might be to a kid, but
no, she's telling you off, Stephen.
It definitely wasn't yours to my 7-year-old.
Yeah, 7-year-old boys are here, so yeah. Look, as we said at the start, we just wanted to have this conversation, and without presetting any thoughts about setting some interim guidance out or how we'd set something up. But what do you think, Kit, in terms of next steps? I think this has been a really good discussion, and perhaps has clarified a few issues in my mind. But I did find in particular the TCDC case and the way David Kirkpatrick sort of thought about the relationship between restricted discretionary needing to be very clearly restricted and not open enough to go over into discretion. And we can keep an eye out for that type of thing as we go through.
Yes. And that's absolutely accepted. Matters of discretion should not be drafted that widely.
Yes. But then again, if there's a simple way of clarifying it with just some introductory words to the tables, which just clarify what they are, that would be, a pretty simple fix, which I think we could do on the basis of clarity across the plan. But Kit, do you think we should put anything further in writing in terms of our thoughts to guide a response?
I think, look, I'd like to have another chat to Commissioner McMahon about it and maybe confer on what we've heard today. And it may be that we could issue a minute so that so that Sarah and the council lawyer and the team can all sort of focus on things that we've noted in this discussion. For things going forward, I think where this might end up is that in the context of 42A reporting on future chapters, this would be one of those things that is sort of checked while the analysis of the submissions is going on, and potentially then separating by way of recommendation suggestions to ensure the criteria are clear and meet, you know, the requirements of the Act and good drafting. And so then we could see those as a separate think piece to what the submitters are actually asking. I know it means more work, unfortunately, but the other option is that we sort of get to the end of all of these hearings and we're left with something that we're still not comfortable with, and then you've got to let us write the whole thing to some extent. So I'd rather we sort of see this as a work in progress through the various chapters. And for a lot of them, there may not be that much involved because there's a degree of repetition between the matters, and it's all about making sure that they sort of meet a certain gold standard. Yeah, so I think what we might do is let you guys just pause and think about it, and we might have a conference and then issue a minute, and that can set out some guidance for how we'd like you to sort of think about it in the course of future reporting on the chapters.
Mm.
Is that helpful? Yeah.
Yes, and just on that then, I'd encourage you to have a look at the Auckland Council v Budden case, Commissioner Littlejohn, because that does also talk about sections 8783 and the fact that RDA rules function to both prescribe and proscribe what is available for consideration. So there are some other cases that do discuss it other than Eden's, which might be useful for you all to keep in mind too as well.
One of the joys with planning law is that to understand any proposition in a decision of the Environment Court, you've got to understand the plan that they were talking about.
Yeah, exactly.
And Budden, by reference to the Auckland plan, the RDA rule was a construct of an activity status, matters of discretion and assessment criteria. So the court there refers to RDA rules, both proscribing and prescribing, on the understanding that the way they were constructed in that plan was there were three separate components to them. And so in that sense, the court's observation makes complete sense. If the court had been faced with, you know, a set of criteria that were both evaluative and sort of didn't know whether they were prescribing or proscribing, you might not have got the same, sort of proposition. And admittedly, Judge Kirkpatrick's decision in the Eden case was also dealing with a structure of a rule which had those three components: status, matters of discretion and criteria. So the ones that are probably most instructive are those where there's been any judicial thinking on plans that have used the formula that is adopted here, where it's a much more of a combined approach to see whether there's been any adverse commentary about that. I don't suspect there are cases, but it may be that we can find them.
Yeah, Trojan Holdings Limited, the Queenstown Lakes District Council, does talk about the matters of discretion as well. I'm happy to maybe give you a list of cases just to have a look through.
Yeah, I mean, if you, that'd be helpful. And I mean, I don't expect a 20-page memorandum, even if it's just some references, because I'm happy to do the research on this. I started this I started this conversation, so I'm not going to abandon it. I'll make sure I do some homework on it and keep myself satisfied.
Cool. There was just one other issue. Sorry, unless there's any.
I was just wondering whether Commissioner Coffin had anything to add. He's been listening carefully.
Well, I think it's already been said. My key issue was just the plan providing enough clarity and thereby providing certainty in the provisions that people knew what it actually meant. And then I'd already started looking forward into the chapters and noticed the number of matters of discretion where they could mean anything, or they were very subjective. But those are really more matters of substance, perhaps, than consistency. But I think those matters we've covered the matters that I was concerned about. But I suppose the last thing was just really want to just put our hand up early rather than later, because I know we've got some miscellaneous matters as the very last hearing that we have, and I was particularly worried we'll get there and go, actually, if this was written in a different way, it would be better, and we would be left with writing it, which I certainly don't want to do at the end of the hearing process, is rewrite a plan. So this and there'll be a few other matters that I think will come up shortly, deal with them early rather than later.
Understood.
So Lauren, you had something else to add?
Just one of the other observations of Commissioner Littlejohn's was around the what the effect of non-compliance with the effects standards is, and whether an activity status should be specified in each standard. Did you want to discuss that now, or is it time?
Oh, look, yeah, I'm happy just to say, I mean, if you look at the way, I mean, I think I might have expressed it. I worked it out eventually. If you look at the rule and you are only RD, you're RD if you don't meet the standards, and then you go to the standards, and if you don't meet them, I think you just got to hold open in your mind the fact that the non-compliance with the standard means you're not complying with the rule, and then that triggers the RD. So I worked that out, but then the confusing bit is that adjacent to each standard, you've got another list of matters over, matters of discretion. And
yes.
Look, it might just mean that back up in the introductory chapter, there is a brief statement there that says the rules are structured like this, and more informative, so that rather than going through and writing RD on each chapter and making it look like its own rule, there is a catch-all rule at the front which says that if you don't comply with the requirements of a standard, the activity status is restricted discretionary, and the matters of discretion are stipulated next to it. Because at the moment there's not a clue other than non-compliance with the standard within the context of the rule that leads you to the path of another restricted discretionary consent.
Yes. So
anyway,
my only comment in relation to that would be that for some of the rules, compliance with the standard is not required. So there are some permitted activities that don't require compliance with the effects standard. Where you are required to comply with the effects standard, it will be set out in the particular activity rule. And then so you go down and check that you've complied with that effects standard. If you haven't, you'll trip to RD, and then for any of those rules which follow that sequence, there will be an assessment criteria in the RD section of the activity rule, which says the extent and effect of non-compliance with any relevant standard and the matter of discretion in the infringed standard. So in that way, the two are linked.
Okay. Yeah, I sort of worked that out. Yeah. The other one as well was the comment I made about positive effects, and I don't know, maybe that is heading into that realm of substance to some extent. Having
That's
said
a great
that,
point. A really great point. It is.
Having said that, when I think back to the Auckland Unitary Plan when it was notified, it didn't have that chapter C where it's got a whole lot of sort of operating instructions for the plan. That was invented by the panel on the way through.
Right.
But none of it was identified as out of scope. And they had to list their out of scope matters, so none of it was listed like that. It was sort of treated as these are the algorithms to work this plan, and it was all sort of, we're doing this so that everyone's clear and clarified. And they added in at that point that general, just because we haven't talked about positive effects in the context of a restricted discretionary activity, you should assume that they are, so that they became a matter for consenting when you were assessing a restricted discretionary activity. You might not need it because the policy framework may be cast as enabling enough to give the decision maker encouragement around enabling the activity. And then you only just need to focus on the adverse aspects of it. But yeah, I don't know. I'd be interested at some point to get the council's view on it.
Yes. Yeah, I mean, that is a big question, that a big can of worms that you've just opened there. So yeah, we'll think further on that and see if there's a way that it can be brought in some way, or whether it's already satisfactorily dealt with through the policy.
Yeah, I mean, the more when I reread Eden last night again, the the clear view is that just because you're restricted discretionary doesn't mean that the objectives and policies are irrelevant. In fact, you approach an RD in the same way as you do any other application by going down section 104. The RD things only really kick in when you then work out whether you're going to grant or refuse consent. And so you can hold in mind the stuff that came out of your analysis of the broader policy provisions anyway. So it may be that it's not necessary, but again, something to think about.
Yeah,
Can I
definitely
just
worth
ask a
considering.
question of you both on that? When I read the Eden case, you seem to be saying that there were some practitioners in that case that were suggesting that objectives and policies were not relevant to considering restricted discretionary applications, and he wanted to put that right. But then he makes a finding that I think, and this is where I think, Sarah, some of the matters of discretion includes reference to particular policies which have a list of evaluative matters. That's right, isn't it? Yeah.
Yeah. We do use that technique. You'll find it particularly with in chapters like that are subject to section 6 matters. So often that they used it here, although we have used it in the Earthworks as well. It's not so much in the zone chapters so much. It's those section 6 matters and a few district-wide matters as well.
Yeah, but again, if you wanted to make a note of paragraph 119, which I've got in front of me, that decision seems to be saying that you can restrict matters to certain objectives and policies, but then you also have to look at the whole provisions, including all of the objectives and policies as well. So that, on one hand, he's saying you can restrict through using specific nominated objectives and policies in a section of the plan, but by the way, if you do restrict, you've got to look at everything else as well. So I wasn't quite sure, and whether he was just what that actually meant. And that's more
I'll give him a call.
To give me
I'll
a
give him a call and find
interpretation.
out,
Yeah.
Sarah, and Lauren will already know this. The Auckland plan does make quite liberal use of that technique of cross-referencing to policies, but only in assessment criteria. It doesn't do it in the context of matters of discretion. The matters of discretion are very blank, simple statements, traffic effects or traffic safety, whereas the assessment criteria, that's where all the meat hangs on it. And so they make a lot of cross-referencing to policies there in the context of assessment for restricted discretionary matters. All right, I just pity any person who's jumped onto the Zoom call at 5:30 and is listening to this conversation. So I think we've said enough for the day, haven't we?
Yes. Look, I see, and I'd like to acknowledge there's lots of council people here, but there's Maria and Damien and a few others that are listening intently.
I suspect they're all sitting with their microphones off, laughing at us and drinking.
having a glass of wine or something.
Ellerton will be in particular. I know that's what he does.
I'm gonna not make a comment by commenting that I'm not commenting.
Yeah. So look, I think Kit's right. We have discussed this enough. We've actually got quite a lot out of this, and hope you're just thinking about this as hard as we are. I'm sure you are. Just looking for good practice and the range of experience we have with all these different plans. So thank you for the discussion. And I'm mindful, Sarah, that you're hearing 5 authors are working to the end of next week now. So I don't think we can impose on them any further thoughts. They'll be busy just getting getting their reports together. So we might that gives us a bit of time to think about things through the rest of September, I think. So let's not rush it. Let's just we'll ponder as a panel. We'll do a minute, and we'll ask for some feedback in time. This does raise, or with a specified time, this does raise a process matter, which I think we do have to think about, is if we're asking the council planners for their advice what about the other parties involved as well? We'll have to think about that when we issue our minute, I think. Even though this is more form over substance, we might be able to restrict it just to the council team, but we'll have to have a think about that. All right, nearly 5:30. I think I closed hearing 4 prematurely on Monday, but I think this is formally the close of our hearing 4. So thank you very much, and we're back on the 4th of October for hearing 5, and that's the full panel, and that's going to be interesting, and we look forward to that. So thank you very much, and thank you, Julie, and everyone for helping us out, and we'll talk to you again then.
Thank
you very much.